May it please your lordships. May I be permitted to move an unlisted motion, my lord?
Okay.
Today.
Regarding?
Well, it's a service matter. There was a transfer order. The transfer order has been stayed by this honorable court. And in the transfer order, clear observation has been made that there is no element of any misconduct. Now, my lord, without taking any leave of this honorable court, I have been suspended. On the contrary, there is already an observation in the order that there is no element of any misconduct. Now I have been placed under suspension, and the charge has been, I am an executive engineer, charge has been given to an assistant engineer, not even to an assistant executive engineer. So it's an absolute case of malice, Miller.
Let us look.
I'm deeply.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 2, contempt case. Lordship, here the senior counsel.
Item 2.
Yes, Lordship. Senior counsel Fiji Sekia will appear on 23rd. Today, because of his health issues, could not appear. So this matter may be fixed on 23rd. Day after tomorrow, Lordship.
You want this matter to be fixed on the
23rd.
tomorrow? Okay.
Day after tomorrow.
Is grateful by Mr. Kelo and counsel for the petitioner. This is matter again on
22.
22.
23.
23. Okay.
Yes. Deeply honest.
Lordship, I'd like to mention item number 17. Lordship, the conducting counsel at attack is on. Is on the
Item
conducting counsel.
17.
Lordship,
Item?
17. Lordship.
What do you want?
The adjournment was. That conducting counsel at attack is out of position for some domestic issue. It's also concern from this opposite party.
We'll see. See the office note and pass order. Okay, wait for some time. We'll adjourn it, but wait for some time. Let us see the office note. What is it has been listed for? Okay.
May I, Lordship? I'd like to mention item number 25 on behalf of B. Pathak, Your Lordship. Due to some personal difficulties, he is not able to appear today, Lordship. So this matter may be listed on 23rd, Your Lordship.
Who could not appear
B. Pathak.
for petitioner?
Yes.
Okay. What about the respondent? Have you informed?
Yes, I have
Lordship, I am
taken-
for respondent.
No objection. No.
Lordship, no objection. I'm appearing on behalf of M. Kato, DSJ M. Kato. For respondent number 1, 2, and 3.
Miss
Tirimi.
Counsel. Your name is there?
My name is not there.
Appearing on behalf of Mr. Charles Modi. Counsel for the petitioner. Praise for adjournment of the matter for how much that?
On 23rd, Your Lordship. 23rd of this month.
Praise for listing this matter on 23rd. To which Miss,
Yasmin Gao.
no objection, 23rd.
Sorry.
For 23rd, you have no objection.
No, Lordship.
Counsel appearing on behalf of Mr. Marto Gato, ESTI, has no objection. Accordingly, list is on 23rd.
Bless you, Lordship. Lordship, I beg to mention item number 26.
20?
26.
Okay.
On behalf of the SDI M. Kato.
Have you informed petitioner who is for the petition?
No. Lordship, we have taken consent from the petitioner party.
Okay. No objection. Okay. Miss Philly. Counsel. Is appearing on behalf of Mr. Marto Kato, DSTI. Praise for adjournment for
2 weeks.
2 weeks. 2 weeks. Mr. Dicky Pang, Counsel for the petitioner has no objection. Accordingly, is grateful from at least this matter after 2 weeks.
My Lordship, I beg to mention item number 12. The conducting counsel is out of station. Please adjourn this matter and list after 3 week.
Out of
I have taken the consent
who
from,
is out of Rajesh Sona?
yes,
Miss
M. Jerang.
some Mr. conducting counsel, Mr. Rajesh Sharma, is out of the stage, therefore pray for adjournment of the matter. She has also obtained consent from the land council from the, of the respondents. Wait, the prayer is allowed, please this matter after
3 weeks.
3 weeks. Okay.
Adjournment.
Lordship, I'd like to mention item number 5. I am appearing for the petitioner. The conducting counsel, due to his sick health, seeks this court's adjournment for 3 weeks, Lordship.
Item 5,
Yes.
Motion.
It's from Hassan.
and you are seeking adjournment for 3 weeks.
Yeah.
That's a caveat also. So,
No objection, I am forgiving.
Mr.
A. Gamre.
Land counsel appearing on behalf of Mr. Vijay Jama, land counsel for the petition.
Lordship, the main conducting counsel is Niranjan Sharma. It is wrongly reflected
Niranjan
here.
Sharma. Praise for listing this matter after 3 weeks. We wish the land counsel for the respondent has no objections. They are allowed. List this matter after 3 weeks.
Obliged.
Okay.
Lordship, I would like to mention item number 16. Herein, we need to file reply in the affidavit in opposition. We need to file reply in affidavit in opposition of the respondents.
You want to file
Yes,
item,
16.
Mr.
S. Siram.
Who is for the other side? Whether the land counsel for the respondent is present? No,
Present respondent, we have informed
not
them.
present. Wait for some time there.
We have informed them.
You have informed?
Yes.
Okay. Land counsel for the petitioner. Praise for, earlier also you made a prayer,
Earlier, we made prayer for adjournment.
adjournment.
Yes.
Earlier, whether you made prayer to file affidavit in reply.
No, no.
Nothing.
Earlier, we did not receive the affidavit in opposition.
Okay, some is that we had received affidavit in opposition filed by the respondent and prays for some time to file affidavit in reply. The prayer is allowed. List this matter after 3 weeks. Okay. Thank you. Number 1.
Lordship, this is a contempt case. At this stage, a notice is issued. Kindly see this.
What is the direction?
It is a page number 18 annexed to. Page number 18 annexed. This court direction is page number 16. 1456. Court order is annexure 1. Direction is operative portion is page number 17. Para 5. Yes. May I read the complaint? The petitioner herein is directed to approach the jurisdiction of Deputy Commissioner on 17/8/2024 for being furnished with a copy of the award, and the Deputy Commissioner shall also inform the petitioner about the manner in which the said award was so published. But this exercise was not done by the concerned Deputy Commissioner. Accordingly, the petitioner was never been informed of what is the process of this land acquisition process and till awarding of this till award. Accordingly, on 18 of thereafter, when there was an inaction on the part of the deputy commissioner, page number 18, annexure 2. Kindly see, the petitioner has written this letter, application to the concerned deputy commissioner for,
Okay, we'll issue notice.
yes,
Or Mr. Lijapa, land council for the petitioner. This is an application filed under Article 215 of the Constitution of India, read with Section 12 of the Contempt of Court Act 1971 and Rule 9 of the Contempt of Court within bracket Guwahati High Court in bracket Rule 1977. 774. Deliberate violation of the violation of this court order details of 24/7/2024. Passed in WPC number 208/2024. Start, issue notice. Returnable by 4 weeks. Start, the petitioner shall take steps upon the respondent by a registered post as well as by legal process within a week from today. List this matter after 4 weeks.
kindly see, Lordship, page number 4 direction is, page 14 annexure 1 is the court order. And direction part is, page number 16. The language goes, on such representation being filed by the petitioner. Filed by the petitioner.
No order was passed thereafter.
Considered in accordance.
You have filed representation.
Yes.
When?
On page number 17, annexure 2, 17 August 2024. First representation was filed and a court order was enforced.
That's what received.
Yes,
Where do we find?
receipt is, receipt letter is received on 12 August itself. Before the deputy commissioner office,
Have you filed any reminder thereafter?
no reminder. We have visited number of times.
Who is the present incumbent?
Incumbent is,
Respondent number 2.
respondent number, yes.
The respondent number 1 is no longer there.
Yes, no longer here. He has been already transferred as joint secretary, Itanagar, hydropower,
So you want this respondent number 1 also?
one was supposed to dispose the matter. During this period, it was submitted.
Hmm?
During this period, he was in, this.
But he is no longer there.
He is no longer here.
So still you want to include him.
He was supposed to dispose the matter, but he is no longer there. He is now as a joint
Now
secretary,
you see,
hydropower.
the
Now,
new incumbent has been
new
posted in
incumbent
his
has
place.
already reached.
Have you issued, you could have submitted one reminder. Have you
Yes,
submitted a
yes.
reminder
Reminder also I have
to
some.
the present incumbent? He would not know
He knows.
how.
I have, because I have met number of times
No,
with the
where
present incumbent.
do we find on the court?
That copy is not enclosed, but we are meeting. I have apprised the matter to the new incumbent also. New incumbent is aware of the court order.
Now this was submitted 12 August. And when this previous
see all-
authority
Judgment,
was
kindly see,
transferred, when this new incumbent joined,
Kindly see, I have written there. Here.
Hmm?
Here is the Adjournment. Kindly see para number 6, page 7. Here is the Adjournment. Honorable Guwahati High Court Sergeant says, has been filed press representation of 12 August 2000 and closing a copy of
Yes,
the
that is there. You have filed, but then whether,
Contempt number 1, Hage Lali, with a prayer for promotion. However, the Deputy Commissioner in Contempt neither considered his prayer nor disposed the representation. Accordingly, then Commissioner, although direction was passed for disposal to the same, in the meantime, he was transferred out from Inkyong. During this period, he did not consider.
when he was transferred,
Date of transfer is kindly seen in para 7 on 6 August.
what is the date?
Or not 6 August. Representations was 12 August.
When he was transferred?
18 January. First representation was filed at the 42 January.
Okay, add Mr. P. Kapali. And answer to the petitioner, similar order, huh? You should not. This is similar order, and a petition application file under section article 215 of the Constitution of India. Read with section 12 of the content of court rule 971 and rule 9 of the content of court Guwahati High Court rule 977.
Contempt number 1 was transferred out from Inkyong on 18th October.
Surveillance of the honorable courts order dated 6/8/2024. Passed in WPC number 575/2023. Issue notice returnable in 4 weeks. The petitioner shall take steps upon the contents by the register court as well as by usual process within a week from today. Start this matter after 4 weeks.
In this case alone, kindly see, this execution has been executed by the concerned officer, PO, on the basis of PEC documents, PEC board order committed by them. PEC, it was PEC Kabang decision. Decision was PEC. That is the issue here. Kindly see page number 30.
Decision of the
Decision of the Kabang was PEC.
customary court.
Yes.
PEC.
Yes. That is why. There is a Kabang, but on the Kabang, there was no decision. However, that self-manufactured documents was produced before the circle officer saying that Kabang has been done. That is the issue. Kindly see page number 30, annexure 13. Page number 38, annexure number 13. Kindly see. This is the clarification given by the Gaubura. And page number 38, annexure number 8. Annexure number not 8, annexure number 13. May I read the contents? A clarification letter signed by the 5 Gaubura of Payam Circle stating that Kabang decision dated such and such 15/8/2024 submitted to the office for execution of Tagin Tarin is false and fabricated. Was received in the court of the circle officer Payam during the hearing of execution of the case of Tagin Tarin versus Tagin Tabang and Tadik Tabang, due to which meeting was adjourned. Now, therefore, in order to verify the contents of the clarification letter as well as the Kabang decision of the dated ordered Kabang dated 15/11/2020. The following Gaubura Payam Circle are hereby directed to appear in the court of the circle officer Payam on 4 June 2025 at 10:30 This following Gaburas were called here. In the order, the circle officer has said, kindly see, this is my respondent. Kindly see, copy two. Copy two side, kindly see, third number. All above mentioned Gabura of Bango Secretary for Information and Compliance. Then fourth number, kindly see, Siri Tagin Taring, my respondent, degree holder of the information and direction to attend the hearing and to bring the original copy of the Kabang minutes submitted in the office of the execution application. Whereas this is not the procedure, Lordship. The Kabang decision, as per the Gaubura proceeding, Kabang decision is supposed to be kept by the Kabang authority who has conducted the Kabang. But in this case, although previously Kabang was done, but in the Kabang, the previous Gaubura has clarified that although we have conducted the Kabang, but there was no decision. Then what had happened later on, this respondent has said the Kabang was conducted, that was done in my favor. So the circle officer concerned, who was the executing officer as per the Regulation Act, he was directed to, that adverse party was directed to produce the original documents. This is because the Kabang authority was not having any original documents of the Kabang in question. So I have seen the record also. This Puja Swanam circle officer himself was the, Kabang has been conducted. Dispute was with regard to land because frontier highway is going on there. In the Puja Swanam, the circle officer is there. He is the chairman. He is the chairman of that chairman of Bile meeting, page number 30, annexure 5. Tagin Taring, letter written by this respondent. Page number 30, annexure 5. Kindly see. As per the, on the basis of that, yes, this, my respondent, this Tagin Taring, yes, Molo village, he has said, what he has said, Tagin Taring has said, he is holding the Kabang, that he has kept the Kabang order, that fabricated Kabang order, which has been executed by the circle officer. On the basis of this letter, kindly see, as per this 13 March 2025 letter, kindly issued executed order regarding land dispute between Tagin Taring, Tagin Tawang and Tadik Tawang. This circle officer is, this is the circle officer who is exercising his power as an executing court under the Regulation Act. So she is the chairman of that area, chairman of that land disputed area, chairman of Bile Miging Trans Highway Payung District, Siang District Ownership Protest. May I read the contents too? Most humble and respectful, I have the honor to inform you that the good office about the local Kabang decision which are held on 15 November 2024, Friday at Molo village regarding land dispute case between Tagin Taring, Tagin Tawang and Tadik Tabang. After getting all evidence and spot verification, the House President decided that mentioned plot number 21, 22 and 23 belongs to Tagin Taring, because he is saying that although no proper Kabang decision was passed, when the village authority himself, who conducted as a chairman, deposed before the executing court that no Kabang decision was passed. Even then, this circle officer has executed the order saying that there is one Kabang decision. When the authority who is said to be passed that Kabang decision, he is denying the fact that there was no Kabang decision. Even then, the execution order has been passed on the basis of which this land compensation authority is going to disburse that money. The chairman, the circle officer who is exercising the dual role here, who is as an executing court as well as the chairman of the.
Let us see your prayer.
Kindly see, my prayer is at this stage, I would pray for this such stay of the operation of this execution order. My ground for revision is also page number 13, para number 17. Clearly indicates that may I read the content why I am seeking revision against this execution order. Because there is no record in the Gaobura court. As a customary court, they should have the record. But in this case, the respondent was having manufactured documents. The record was called from the respondent side. Number 2, B, no Kabang decision. There is no Kabang decision. It is at, I am to say, there is no Kabang decision, final decision on 15/11/2024 with regard to that disputed land. There is no application of mine by the circle officer concerned while executing the court after hearing the parties. That completely finding was perverse because the chairman of the Kabang himself deposed before the circle officer saying that there was no Kabang, no final decision from their side.
Lordship, this petitioner is confusing the court also, Lordship.
Issue notice at the moment.
Only notice, Lordship. Otherwise, if Lordship see the this impugn order,
Yes.
it's very clear, Lordship. It's clear, Lordship. In the impugn order is at
Here,
page 39. Lordship.
yes. But see, the.
Lordship,
serial
here,
number one,
out of
statement
11,
of the CABA members, 1, 2, 3, what, perhaps, serial number 1 has headed the CABA decision, and he has disputed saying that.
One,
that the
1, 2,
CABA
and
decision is fabricated.
yes, 1, 2, and 3 only. From 4, 5, 6, 7, 8, 9, 10, 11, Lordship.
Okay.
They are
But
saying,
he was heading,
uh,
number 1 was heading the CABA decision.
if Lordship see this serial number 4, 5, 6, 7, they have said there was Kebang. Kebang has held, the session was
Call for the
taken.
record and examine. Call for the record and examine, let us see. We'll call for the record. and
Record,
Examine,
Lordship.
because there is a dispute. The
Of course,
person
Lordship.
who headed the CABA decision is disputing that there was no decision. Is it okay?
Only three persons are disputing, Lordship. Otherwise, out of 11, Lordship, 7 have said Kebang has happened and the session has been taken. Lordship. And then the documents which he is saying, Lordship, in this page 39 only, Lordship, page 39 only in the beginning, it has been written, Lordship, stated the Kebang minus of 15/11/2024 in original submitted by the decree holder was read out, Lordship. It has been submitted in original, Lordship. If your Lordship see page 39.
And the copy is CABA decision 15/11. The respondent, it appears, has not signed it. No signature. You see? Where is the CABA form?
Kabang purported Kabang decision is Annexure one, Lordship.
Annex of one page.
Yes, page number 19.
Kindly see
Type copy is page number 20.
the signature of
Only my respondent has
respondent.
signed. I have not signed.
And then the petitioner has.
I am Tagin Tabang. I have not signed.
Tagin
This is-
and Tagin.
Yes,
Tabang.
except,
Not sign it.
yes. That is
And
the
then
issue here.
Can you see, can you come to page 22 also?
22.
The this is also not in continuation of the earlier. The serial number is again.
Not legible in,
one.
my page is not legible. Lordship,
Page 22.
not legible. Then Lordship, so notice maybe issue,
Okay.
let notice. It has been signed or not, it's not very clear, Lordship.
By filing this application under Article 227 of the Constitution of India, read in section 115 of Civil Procedure Code 1908.
Lordship, I am for respondent number 2. Only 2.
This is not the same. But you are not challenging the Cabal decision.
I have, I think, challenge.
No, in the prayer, Lordship,
You are agreed by the execution.
Execution, yes.
yes, that only.
Because there was no Kavang decision. That is the issue here. This is a completely
There is
fabricated.
no Cabal decision.
Lordship,
There
this
is-
is disputing.
If there was a
This is
Kavang decision,
disputing now. Very.
the
This
chairman,
fact,
chairman himself is saying that I have not passed any final decision.
The
Even-
execution of order.
Where is that?
Kavang chairman saying.
Dated 4/6/2025. Passed by the certain officer I PAYUM. District Siam. In execution. Petition number EYM stroke ZUD dash 12. Exit and EXEC bracket close stroke 2024. Dash 25 stroke 471. Within bracket Tabi and Taki Taring. EGIA Taring versus. Say Taking Taring versus Taking Tapang. Bracket close. The case of the petition. Is the case of the petition. That's. There other cases on sitting on the 11/2024. Again, no Cabal decision. The. Impugn Cabal decision annexer. Cabal decision dated 15/11/2023 is a fake Cabal decision. For which the.
Annexure
Against
15,
which? Against which?
FIR has been lost.
The head GB.
Yes. Saying that court of this Kavang decision has been fabricated.
Tabang Karang. That is the Cabal.
AGB Molo,
And
Tadik
Tadik
Yanying,
Yanyi.
AGB Molo, GB Molo.
Village. And. written FIR before the officer in charge, police station time or district. Respondent hearing, huh? Stating that no KEBA decision was drafted before the village authority. Stop. Sorry, accepted notice on behalf of the state respondent number. You are for respondent number? Two. No formal notice will be issued to the state respondent. Start with the petitioner shall take steps of the respondent by the registered post as well as by using post within a week from today. List is matter after 4 weeks. In the meantime, the operation of the impugn execution order dated 4/6/2025 fast and where is the case number? Execution case number PYM stroke JUT dash 12 within bracket exit bracket close stroke 2024 dash 25 stroke 471 shall remain stay till the next returnable date.
My lord. Petitioner is aggrieved by my lord the action of the respondent, my lord. In fact, the petitioner, my lord, he is having a vast area of land, my lord, at Dari, my lord, Leparada district, my lord, which he has inherited from his father, my lord. And my order, my lord, it is not disputed, my lord, the AGB of the concerned village, my lord. He has also certified that the land where upon the present PHE, my lord, Public Health Center, which is being upgraded, my lord, to CHE, is constructed on the land of the petitioner, my lord. Not only that, my lord, there is one police outpost, my lord.
Since when?
Since, my lord, this May, my lord. May of this.
They are under operation since when?
My lord, of course, they are not this occupying the land this permanently, my lord. There was earlier, my lord, this temporary, my lord. My lord. No, my lord, it is not yet, my lord, this started, my lord. The construction, of course, it is going on, my lord. But
Earlier,
there is no outpost, my lord.
Earlier, where they were?
Earlier, my lord, that was run from this Basar.
Some other place,
Basar, my lord.
not from the present place.
Yes, my lord.
When they started occupying?
Oh, my lord, from this May, my lord. This May, my lord, they have started this to construct building, my lord. Against which,
on what basis?
my lord,
On what basis?
no,
they
my
have
lord,
started?
my lord, they are encroaching upon my land, my lord. I have filed several petitions before the deputy commissioner, my lord. But my lord, since I have to move here and
Where
there,
is the document showing that this land?
my lord may kindly come to this. My lord, first of all, my lord, come to page number 17, my lord. And lecture 1. In fact, it is series, my lord. This is certificate, my lord, issued by GPC, my lord. This Panchayat chairperson, my lord.
What other document?
My lord,
What other documents you have? Other than this, other than GPC of your own village?
yes, my lord.
This is GPC of your own village?
Yes, my lord.
Okay, now what other document you
And
have?
other document, my lord, may kindly turn to page number 18, my lord. This is the document, my lord, same certificate, my lord, issued by GB, my lord.
No,
Head Gambura, my lord,
no.
of the same village, my lord.
There any documents issued by the government acknowledging your land?
My lord, yes, my lord.
Of the president?
That, my lord, will find. Earlier, my lord, during the time of Mr. Gojen Gandhi, my lord, in the year, my lord, 2014 to 19, when he was the member of this legislative assembly, my lord, he has approached me once, my lord. My lord, may kindly come to page number 28, my lord. This document also reveals that, my lord, the land in question is the land of the petitioner, my lord. Enclosed, please find here the representation received from Sri Bajum Bam of Dari village under Dari Sarkar Bhubaneswar district requesting for appointment of his wife, Srimati So to Group B, post of PHC Dari. It is also made to understand that the said Dari PHC has been established in his ancestral land, my lord, of late Karbaba with a promise to provide a job to his family members against the land compensation, but no action has been initiated so far. Therefore, DMO would like to consider case of Sri Jumdai Basar. My lord, like this, my lord.
This was way back in the year 2007.
Yes, my lord. So, my lord, here also, this letter also indicates that the.
So see, no, you said that during, since May only. This since 2007.
I have submitted, my lord. Earlier, it was PHE, my lord, Public Health Center. Now, it is now being proposed for this upgradation to CHE.
Maybe, but then since it was since 2007, it was already there.
My lord, that was this function temporarily, my lord. That is, my lord, not disputed, my lord. And my lord, it is also not disputed that the land whereupon this PHC is being constructed, my lord. It is the land of the petitioner, my lord. This is the letter of the then MLA, my lord, who was also the chairman of APEDA, my lord. Now,
So there was only a promise to provide jobs to the
yes, my
family
lord.
members.
Yeah, but that was not done, my
The
lord.
land was already given to the government.
No, my lord.
And thereafter, the government has established
No, my lord.
only what you can, you were asked where this is by MLA. And it was requested to provide a job to the members of the family members. Land was already given earlier.
My lord is very this is well aware, my lord. The land, the government land, my lord, how a land become a government land, my lord? It is either by acquisition or by donation, my lord. Only there is two mode, my lord.
First, you have to prove that this land belongs to you.
That is, my lord, the village authority, my lord, who is the authority of the village, my lord, they have certified, issued the certificate, my lord, saying that the land whereupon all these structures are being constructed is the land of the petitioner, my lord. My lord, in the village, my lord, it is the SGB, head Gampura, my lord, who has the authority, my lord. And
And then the police station since when? The PHC, it appears since 2000, prior to 2007. Police station.
No, my lord. It was not there, my lord.
Since when?
It is now being constructed only, my lord. Earlier, it was not there, my lord. My lord, I have even annexed the photograph, my lord.
No, where is the document showing that it was to be
Page
established?
number
newly?
31, my lord.
Where is the document showing that the police station or the PHC is to be established newly? And
Page number 31, my lord, is the photograph, my lord.
Hmm?
Page number 31 is the photograph, my lord, of the
No.
police
forget about-
outpost. my
Forget
lord.
about photograph for the time being. The document showing that this PHC or CHC is to be established.
My lord, that, my lord will find in annexure 6, my lord. Annexure 6 at page number 35, my lord. Serial number 4, my lord. Page number 35.
Building has also been already constructed, it appears.
No, it is being, this, it is under construction, my lord.
Under construction.
Yes, my lord. Page number 35, serial number 4, my lord. This is name of the existing PHE upgraded to
So
CHC.
existing PHC,
Dari.
it was existed.
Yes, my lord. I'm not disputing that, my lord. The PHE
Serial
was
number- serial
in
number is
existence,
eight.
my lord.
Serial number 4.
Yes, my lord. Earlier during the PHE, my lord, that, my lord, we are admitting, my lord. And my lord, that was with purely on temporary basis, my lord. As my lord is well aware, my lord. Unless a land is, my lord, donated or acquired, my lord, by the government, my lord, land cannot become the government land, my lord. And my ownership, my lord,
Where is the establishment of the police station?
It
Document
will-
showing.
NHA 4, my lord, page number 2. Page number 29, my lord. This is the letter, my lord, issued by the executive engineer, Department of UD and Housing, my lord, for this restart of the work, my lord. With regards to the meeting conducted so and so, New Dari, under the chairmanship so and so, issued by the Deputy Commissioner, Leparada District, SP Leparada District Circle Officer, Dari Circle, HW of Leparada District, and General Public Dari, wherein it was decided to shift the ongoing construction police outpost at Dari to be shifted to new location having geo coordinates so and so. As such, you are requested to restart the construction of police outpost at the above mentioned site with immediate effect. Further, you are also requested to develop and use the land judiciously, keeping in view the possible future expansion of for establishment of a residential building for police personnels.
Yes.
Yes, Lordship, at this stage, let notice for Lordship, because
My lord, since my lord, the police outpost is being my lord construction upon my lord, my land, my lord, and by using the might, my lord.
construction.
My lord,
The-
work has already been started. It was on existing PHE, my lord. This was already been there and work as it's annexed photograph, my lord.
Existing was PH.
Yes, my lord. That's why we required to see the record, my lord. That's why, my lord, at best, let notice be issued, my lord, since the construction and public interest is involved. At this stage, my lord, no interim may be passed, my lord, because it's of no use, because construction already done, and at this stage, at page 30, my lord, see, it's a public importance project, my lord. Now, whether it's claim of the petition right or not, even if there will be no prejudice.
My lord, only the issue, my lord.
My
Only the issue involved is, my lord, whether the land belongs to the government
Yes.
or not, my lord. That has
My
to
lord.
be ascertained, my lord. For that, my lord, then instead of, my lord, issue notice, my lord, kindly instruct the government advocate to this seek instruction, my lord.
that will
Only with regard that, my lord, if the land has already been acquired or it was ever donated, my lord. That has to be ascertained. That much, my lord.
my lord, one thing, my lord, in this such matter, my lord, importance of the public interest, my lord, utmost public
My lord,
interest.
not
Now, my responsible submission, even if, my lord, this
lord,
construction, my lord, what's playing
not at the cost of the petitioner, my lord. My
Not
lord, petitioner has, my lord.
will not be prejudiced at all. If assuming, my lord, we are not saying anything, but unless we see the record, official record, my lord. Even if assuming it has been done on the private land of the petition, the consequences will follow. He will not be prejudiced, my lord. But what will, if stay orders pass, it will be prejudiced to the public at large, my lord.
Unless,
He'll
my
be-
lord,
he'll
unless,
get-
unless they acquired the land, my lord, and
he'll-
they are constructing the structure on the acquired land, my lord, then
If-
my lord, this construction must be stayed, my lord.
Well, otherwise, so for construction, and if it's not acquired, for time being, and assuming it's not acquired also, in that case, my lord, it will be acquired and he'll be given whatever he's entitled for, my lord. So what is the, there will be no prejudice.
Accorded past, my lord, accorded, my lord, use their mind, and my lord, on their own, they cannot build any structure on the land of the petitioner, my lord. They cannot do like that, my lord. The state cannot act like that, my lord.
The petitioner is claiming possession of vast land, lane measuring 12,58,660 square meters at Gari, Leparada district. Possession of inherited vast land. It is Dari. At Dari.
Yes, my lord.
Which has been certified by the Gram Panchayat chairperson and the GB of Old Dari, Leparada district. Stop. It is the case of the petitioner that the land has neither been acquired nor donated by the petitioner. To the government. However, despite of making repeated representation. The government has acquired the land. But instead constructing, and instead started constructing the police outpost and for upgradation of the CHC, PHC,
CHC now.
upgradation of PHC to CHC.
Yes, my lord.
By filing this writ petition, the petitioner shall the impugn order, shall the office memo number EE, number stroke EE stroke UD stroke PSR stroke police outpost, all capital, stroke 2023-2024 dated 28/8/2024, issued by the executive engineer, Department of Beauty and Housing, Basar Division, for construction of police outpost, and the impugn order number MBEV case 914/2025, dated 28/5/2025, issued by the Deputy Secretary within bracket Health and Family Welfare, FW, bracket close, Government of the Arunachal Pradesh, for upgradation of PHC to CHC on the private lane of the petition. Issue notice. Returnable by 4 weeks. Things miss. DHF.
Lordship, here I am representing 1, 2, 4, and 5.
Land Senior Government Advocate accepts notice on behalf of the respondent number 1, 2,
4 and 5 also.
and 5,
And I am for 3.
and Mr.
Standing counsel.
Standing counsel for
Health Department.
the Health Department accept notice on behalf of, for the respondent number 3 and 4.
Only 3, my lord.
Okay, 3,
Yes, ma'am.
then
4 is by.
okay, 4,
1, 2, 4, and 5 also.
okay, see 1, 2, 4, and 5, and then Chicago 4, 2, 4, respondent number 3, huh? No formal notice need be issued. However, the petitioner shall furnish requisite extra copies to the Land Council appearing on behalf of the respondents during the course of the case.
Yes, ma'am. My lord, may kindly this pass interim order, my lord. Otherwise, my lord, my lord has seen, my lord, there is snatching of my land, my lord, without any authority, my lord.
Since the house is under construction, construction, sorry, just a minute, sir. Having had the Land Council properties, it is provided that the construction of the outpost police station and the CHC shall be subject to the outcome of this petition.
Yes, Lordship, obliged.
Obliged.
May I plead, my lord? My lord, it is pertaining to illegal enrollment of 14 persons in the electoral roll. Illegal inclusion of 14 persons from other Gram Panchayat segment as well as the other Panchayat in another Gram segment.
Who are you?
I am one of this, I am the Gram Panchayat chairperson,
How you are agreeing?
and I am also from the from where the other persons are included in my Gram segment, my lord.
Okay, how you are agreed?
My lord, I have not been given this opportunity at the time of the hearing and objection. Claim and objection,
Why you should be given opportunity?
my lord, because these people they have been included. So I want to raise the objection at the time of the hearing, but I was not been given any chance.
Sir, that is why I'm saying, they are not the resident of,
My lord,
they are not the resident of the place.
not resident of the where that they are enrolled. They are no residents. They are from the other panchayats, as well the other segments, but they are not any resident. As per the section 11, that the person who is supposed to be enrolled in that particular segment must be a resident of that particular Gram segment. So here, my lord, this electoral registration officer, K. Pajan district, kindly come to page number 34, my lord. It is visible in 35 is the typed copy, my lord. So here, my lord, one circular is issued. My lord, got it, page number 35, my lord. 35 is visible, my lord, is typed copy. So one circular is issued by the electoral registration officer Panyari Chile. My lord, they are fixing a date. I am on serial number 6, my lord. Serial number 6, this is deed, pipe deed. So my lord,
Serial
on
number 6
serial number 6, my lord,
is what?
page 1, my lord. Page
36.
35, my lord.
What is serial number 6?
There are 2 rounds, my lord.
Hmm?
2 rounds.
This circular is for what? Hearing for claims and objection.
Yes, my lord. Her date was on 27 5 2025. A date was fixed for hearing and as well as the objection.
17/5,
No, my lord. Page number 36.
36,
Yes, 27.
27.
Yes,
Serial number?
6, my lord. There are 2 rounds.
Okay.
27 5 2025. That is fixed for deed Jilla segment, my lord. So on this day, that is 27 5 2025, that was fixed for hearing for all the villages for hearing of claim and objection, my lord. So here, my lord, what happened? As many as 14 persons have been included in my gram segment who are not resident of that gram segment, my lord. So in that issue, we have submitted, we were there to raise an objection on very that day, which was held at PWD-IB at date, my lord. Then, my lord, we have not been allowed to enter into the room of the assistant electoral registration officer who had conducted the hearing, my lord. We have not been allowed. We have been restrained to enter into that room. So hearing could not take place, my lord. Then, my lord, we have lodged a complaint on 28 May 2025. That is page number 53, my lord.
Yeah.
Regarding objection.
Hmm.
My lord, we have lodged this complaint before the electoral registration officer. That is the deputy commissioner, electoral officer. Sorry, this additional deputy commissioner, my lord. ERO is the additional deputy commissioner of the concerned district, my lord. We have lodged a complaint against that issue, my lord, but that has not been entertained by the concerned officer.
Not been entertained means not accepted.
Yes, my lord. And subsequently, my lord, again we have lodged a complaint. Kindly come to page number 57, my lord.
No, the objection was submitted before the electoral registration officer. Whether the application was accepted,
No, not yet entertained, not yet heard. They have received the copy and no any hearing what took place. We have not been heard. It is still pending before the concerned officer, my lord. After receiving the complaint, my lord, that is initial 3, my lord. And again, my lord, on 2/6/2025, kindly come to page number 57, my lord.
yeah.
And again, we have submitted a complaint, apart from the earlier complaint, my lord. This is also pending before the same authority, my lord. Then thereafter, my lord, again we have lodged a complaint before the State Election Commission, my lord. As our 2 complaint has not been entertained by the concerned authority, my lord. We have several times we have visited the office, but they are not going to entertain our complaint, my lord. Then we have compelled to lodge complaint before the State Election Commission, my lord, on 3 June 2025. Now, the Election Commission, it now has forward our complaint to the district election officer, who is also a deputy commissioner in concerned district, my lord. This complaint dated 07/06/2025 has been forwarded to the district election officer, Panjat district. That is page number, my lord. Kindly come to NHR, page number 63. Page number 60 is a complaint lodged before the State Election Commission, my lord. And the same letter has been forwarded to the district election officer, Panjat district, actually on the same day. That is NHR page number 63, my lord. This is also pending before the deputy commissioner. And thereafter, again, my lord,
What happened to this representation, which was forwarded by the Secretary of State Election Commission? What happened to that?
we have submitted this copy to the district election officer, my lord, but it is still pending. And thereafter, my lord, kindly come to page number 66. We have submitted similar complaint before the district election officer, Panjat district, actually on 19 June 2025. But our applications, our complaints are laying there, my lord. And they're not going to entertain our complaint. So,
What is the present position?
my lord, my submission, my prayer before this honorable court is that my specific prayer, direction may be issued to the district election officer to dispose of my complaint, whether it is wrongly or rightly. The concerned district election officer is the only authority to dispose of my complaint, my lord.
Yes.
So, wrongly or rightly. Any other may be.
But this electoral preparation of electoral roll, there are certain procedures. Just a simple direction cannot be met, madam, because there are certain specific dates given when the claims and objections are to be made, when the draft preparation has to be published, when claims and objection, and then what has to be done. The first of all, in this case, my lord will see the draft preparation, the electoral roll. The date is not given when it was this published, but the date for claims and objections has been given. First round was on 17/5, second round on 27/5. Now, these are the dates when the claims and objections, if already made, these are to be heard, my lord. Prior to that, they have to make the claims and objections. My lord will kindly see, I believe my learned friend has not quoted the provisions, my lord. As per the Arunachal Pradesh Panchayat preparation of electoral rolls, Panchayat manual, starts from page 54. Page 54 onwards. My lord, I'll take your lordship to part 2 at section 7, my lord, rule 7. Rule 7, my lord. There shall be an electoral roll which shall be prepared in accordance with the provision of so and so, so and so. Then sub-rule 3, the state election commissioner shall, in relation to the preparation or revision of electoral roll, specify an official order, the qualifying date.
Where are we reading? After 7?
7, sub-rule 3.
3. Okay.
The state election commissioner shall, in relation to the preparation or revision of electoral rolls, specify an official order, the qualifying date, and shall, in addition, in the said order, specify the program for revision, including the period or date as the case may be on the following. A, period for completion of enumeration and preparation of manuscript of electoral roll. B, date for publication of electoral roll in draft, my lord. C, last date for filing of claims and objections shall be within a period of 7 days of the date of publication of electoral roll in draft under clause B. Then D, period for disposal of claims and objections. Date for final publication of electoral roll.
Where are these notifications?
My lord will kindly see, they have to, I'll not burden, they will have to make their objections in Form 7 within 7 days from the publication of the draft electoral roll. My lord will see Rule 17, Rule 19. Rule 18 is for inclusion. Rule 19 is for claim or objection, my lord. Or Rule 18, my lord. Rule 18
18 is for
yes,
objection of inclusion.
for
of name.
claims and objections. Every
Yes,
claims
yes,
for
they have
inclusion.
filed. They have
Yes.
filed.
That has to be filed.
They have filed.
Yes, that should be, we'll have to see whether that filing is within the 7 days specific time.
Where is the notification? Have you annexed all those notifications?
No, my lord, he has not annexed.
No, my lord. Here, on this is the first time hearing of claim and objection issued by the concerned notary.
No, when is the notification?
My lord will kindly see what has been
Where
relied.
is the notification? When you said that you filed objection and you were waiting in the office? When was that?
This is, my lord, kindly come to page number,
Just a minute.
Page
page 36, my lord. Here,
36 is
27.
the period date for hearing of, it says hearing of claims and objections, page 36, my lord.
36.
Yes, the circular. It is of
Hearing for claims and
hearing
objection.
of claims and objection. Meaning thereby, if there is an objection made, if there is a claim made for inclusion or an objection against any inclusion, the hearing will be done on these dates, given dates. Now,
So you have, just a minute. When did you file these claims and objection?
My lord, I am coming to
page
that, my lord.
53.
Page number 36. This is the first circular issued by the electoral registration officer for claim and objection. And subsequently on 28th, kindly come to page number 53, my lord, and etc. So we have filed objection, my lord.
No, just see. Come to page 36. Your page 36.
Yes, my lord.
Can you read the circular? This is on 28.
Claim and objection of Jilla Parishad's constituency of K Panjat district, my lord, in connection with summary revision of electoral roll of Panchayat.
Page 36.
My lord.
37. 36.
Are we in the same page?
This is in 35.
35 is the original?
35 is the original, my lord.
Yes, 36 type
35,
copy.
35 and 6 is the type copy, my lord.
Yes. This is circular.
This is the circular issued by the,
Okay, kindly read. The hearing.
so my lord, here the claim and objection. Panchayat with reference to 1st January 2025,
Yes.
age qualifying date,
Yes.
age fixed on age given below during the office hours at all these ADC offices actually. This is passed around for other the Jilla segment, my lord.
When have you filed objection?
My lord, on 28th hearing was held and on
No, no, no.
28th,
Just please answer. When did you file your objection? Because it was to be heard on 1st January.
no, my lord. It 1st January is the qualifying date. It is the qualifying date. So hearing cannot be take place on 1st January.
Hearing for claims and objections.
It is the qualifying date for revision of this electoral roll. So after that, the date will be hearing date will be fixed by the concerned authority. Then only hearing will be take place. So my lord, page number 38.
Okay, fixed. Okay.
So
Yours
page
is-
number
just a
30
minute, just a minute. Huh?
Yes,
Yours is fixed on 27/5.
yes.
Okay, then my question is, when did you file this objection?
My lord, after the publication of the summary electoral roll.
When?
It is
Have you
published,
annexed? Have
it
you
is
annexed?
published, kindly come to page number 38, my lord.
Page
38, my lord.
38 is copy.
It is qualifying that out
It's a copy too.
electoral roll,
Hmm?
whose names were
38, page 38 is, it is only copy two. The matter of procedure. What is that in your 38? 38, page 38 of your petition, what is there?
electoral roll 2025.
Electoral, that is 39, okay.
Oh. My lord, this is a qualifying date, 1/1/2025. After
Okay.
this qualified date, my lord,
Qualifying date is there.
then this concerned authority, this is electoral officer will issue a circular or order for a claim and hearing of claim and objection. So on this claim and objection was fixed on 27/5/2025 for the first time, my lord. Then,
Yes, there are,
then
my specific question. When did you file your objection? It was fixed on 27/5.
on
But when did
28th,
you-
I have filed objection.
28,
28/5/2025.
hearing was
Can-
fixed on 27/5.
Yes, we have not been allowed to enter into the office of,
When you were supposed to file the objection? When you, because hearing is on 27.
after this circular, my lord.
How?
Because hearing is fixed on 27/5.
It cannot
Then-
be. Hearing, if the hearing is fixed on 27/5, then the objection should have been filed prior to that only.
So our hearing, our claim and objection is to be placed before this hearing only, not prior to that. Our claim and objection, if any claim and objection is there, we have to place that claim and objection before this hearing only, not prior to that, my lord. So this hearing is fixed by giving
The
equal
hearing is
opportunity.
fixed on 27/5/2025.
Yes,
So according to you, you can file only on 27.
28. Just
How it is?
27
I don't
hearing was
understand.
took place and we have not been allowed. And 28 we have lodged a complaint.
Just a minute, kindly let us read it again. Circular, the hearing for, kindly read it. The hearing for claims and objection of, kindly read.
The hearing for claims and objection of Jila Parishad constituency of Kayapanja district in connection with summary, special summary revision of electoral roll of Panchayat Raj with reference to the 1st January 2025 age qualifying date is fixed on age given below during the office hours at all ADC office yesterday.
Okay.
Now,
Now,
so
in your case, it is
now-
fixed on 27.
so in our part, there are two categories, first hearing and second hearing. First hearing is again in page number 35, first hearing is serial number 6/17/2025. Another hearing was fixed for some another village ballot in the first round. And the
May I
second,
clarify?
page number 36.
May I
This
clarify?
27/5/2025
Ah.
is fixed for the village which was not covered in 17/5/2025.
It will be on 27.
Yeah.
Therefore, all the DOs are directed to be present during hearing.
So my village,
Yes,
why,
just a minute, I couldn't understand, please.
My lord, kindly see page 37. There are two rounds of hearing fixed. First is 17/5 and second is 27/5 for his
Yes,
constituency.
yes.
Therefore, all the DOS, BLS of Jila Parishad constituency of Kayapanja district are directed to be present during the hearing of claims and objections. Now, my lord, the applicant listed in forms 7, 8 and 9 shall attend in person with documents in original. Now, what is form 7, 8 and 9? This will clarify. My lord will kindly come to the rules again, my lord. I'll border, my lord.
Applicant listed in form 7, 8.
7, 8 and 9. My lord, what are form 7, 8 and 9? My lord will kindly come to the rules. Rule 17 first, my lord.
Rule
17. 17, 1 second.
page
Page 59. preparation of electoral rolls.
Yes.
Every claim for inclusion of a name in the roll and every objection to an entry therein shall be lodged within a period of 7 days from the date of publication of the roll in draft. Provided the State Commission, Election Commission may by order extend the period in respect of the constituency as a whole or in respect of any part thereof, madam. That is. Now, every claim for inclusion of a name in the electoral roll shall be in Form 4, signed by persons desires so and so, so and so. Every objection to the inclusion of a name in the roll shall be in Form 5, preferred only by a person whose name is already included in the roll. Objection in Form 5, inclusion in Form 4. Every objector to a particular or particulars entry in the roll in Form 6, preferred only by the person to whom the entry relates. Then every claim or objection shall either be presented to the electoral registration officer, be sent by registered post to the electoral registration officer, provided that in claim and objection which may be sent by post shall be rejected by the electoral roll registration officer unless it is received by him within the period specified in Rule 17. That is 7 days, madam. Then, madam.
This the applicant listed in Form 7, 8, and 9.
Yes.
So this 7, 8,
Now,
and 9
now,
means
yes.
18 and 19.
Yes.
No, just let us clarify. This Form 7, 8, and 9 means 17, 18, and 19.
No, my lord. Now, Rule 20, the next. That is what the electoral roll, after claims are being made for inclusion, after objections are being made against inclusion, and after for correction of any entries.
So you are reading 20.
Now 20. What every officer designated under Rule 20 shall maintain in duplicate a list of claims in Form 7. Claims for inclusion, my lord. That a list shall be maintained in Form 7. Then a list of objections to the inclusions of name in Form 8. After objections are made, the entries, a list will be maintained in Form 8 and a list for objection to particulars in entries in Form 9. This is what, when the objections are being received, when the claims for inclusions are being received, when for the correction of entries are being received, then the electoral officer will maintain this list in Form 7, 8, and 9. Now, what the circular says, the applicant listed in Form 7, 8, and 9 shall attain in person with documents in original. Already, that means the objection should have been filed prior.
Yes.
Thereafter, this list will be prepared. Now, what my learned friend is claiming is that this is the first time they are seeing the publication. This is the time for making the claims and objection. In fact, claims and objections should have been made 7 days within 7 days of the draft publication.
There must have been some
Yes.
another notification.
Yes.
That you have probably not annexed.
Yes.
No, I have, my lord, I have annexed
No,
the
because
Form
you-
7.
You
Form-
see, your contention is that on this date, second round, on 27/5/2025, you were waiting along with the application for objection.
Yes, Form 7.
This is probably not correct approach. So you should have filed the objection earlier and your
In
objection
Form-
earlier, in Form 7, 8, and 9. And then the notification says that the applicant listed in 7, 8, and 9 shall attend in person with document in original. But you probably has not filed, that is why you were not called.
Yes.
How you can be entertained
My lord,
as per this notification?
my lord, I want to justify it. My lord.
Please.
On 28 April 2025, the circular was issued by the electoral registration officer, wherein the date of claim and objection was fixed This is the first time after publication of summary revision of 2025. After publication of this summary revision, then only we can come to know that these persons are employed, these persons are deleted. Before that, how we will come to know that this person has been included, that person has been not included. So for that purpose, this hearing is being fixed for any claim and objection. So accordingly, this circular issued, hearing was fixed on 27 May. So accordingly, we have affair there. After getting the summary electoral, electoral roll of 2025 May, we have found that some numbers of people have been included in some other ground segment. So this is the day on 27/5/2025, which we fixed for claim and objection. So accordingly, we have come with Form 7, that is claim, that is objection, my lord.
Mr. Petitioner AG, probably we need to see if
When was
there is
the
another
first-
notification.
Yes, draft publication first done. That is the vital.
Hmm.
From this also we can make out that already there was a
Yes,
draft
but he is
publication.
not convinced, it appears. So
Yes.
you obtain instruction.
Yes, we'll obtain instruction. Let
Okay.
notice be, yes.
You
Yes,
obtain instruction, will not pass any order today. Okay, you obtain instruction, if that is there, if that notification, other notification inviting, then probably.
If
yes,
the
okay.
publication, draft publication once
Yes.
made, it is their duty to
Or
within
should we-
7 days.
Or should we issue notice? itself?
Notice may be issued.
Okay. Mr. Entaji, non-council.
And one more objection, my lord,
Petition.
they are claiming for deletion of 14 persons, but they have not been made party.
Okay.
So the question for,
Those 14%.
they have-
Probably you have to make them party, I think, since your objection is to that. Those inclusion
Yes,
of those
those-
14%.
I will read them, my lord.
Then notice
in
is
the
to be
form
issued
of-
to them as well.
yes.
My lord, in the court title, I will
You,
read them.
you first include them, implement them. Will correct the course title
Either,
and then will issue notice.
So my
At the
lord,
same
I will correct it in the court title. In the
that-
main petition.
my lord, that may be by way of an amendment, or he may withdraw
You
and
have to-
file afresh.
You have to amend the course title.
Yeah, my lord, my lord.
Withdraw and-
Okay, Mr. Entaje, non-counsel for the petitioner, submitted the 14 persons whose name, according to him, has been illegally included in the as a
Electoral.
Electoral.
electoral in where?
In-
Deed.
No, my
Five.
lord, in 5/1/1 dash
In 5,
1,
So,
5/1,
where do we find that number?
my lord. Kindly come to. Page number 7 also.
In
Tar in the method for issuance of appropriate direction. 5/1/2 Namco Tago.
names of person at 5/1/2 dash Namco,
Tago.
NAMCO, Tago Gram segment
Yeah.
under 5/1/1 dash Dem Panchayat, DEMR, Dem Panchayat are not being included as respondent party and praise for allowing him to complete those persons as respondents. The prayer is allowed. The petitioner shall file. I think you have to make one small application then.
Yes.
You have to first make an application,
Withdraw and file.
allow him to make an appropriate application for amendment.
My lord, I may be allowed to withdraw so that
That will-
file afresh, my
Okay,
lord.
Okay, and planning council for the petitioner wants to withdraw this writ petition with liberty to file afresh after making necessary correction.
necessary.
Okay,
arrangement.
everything else? Okay, the petition stands dismissed on being withdrawn with liberty as prayed for. Okay.
All right, my lord.
My lord, this case is relating to eviction. My lord, the father of the petitioner occupied a plot of land in the year 1999. And she was given in the year 2011, my lord. And since then, the land is under the possession of the petitioner. Petitioner is staying in the same plot of land by constructing a OBT house, my lord. And recently, notice was issued against the husband of the petitioner, my lord. In fact, petitioner has applied for land allotment in a year 2020. And that was forwarded to the government for approval. And when the matter was pending before the director of land management department, then notice was issued. Then it was replied by the husband of the petitioner. And the
Director of Land Management,
yes, my lord. It was
husband of the petitioner. Is it nearby the water or what?
no, my lord.
Okay.
Only
Why-
Kacha house.
Why notice was issued to husband?
Actually, complaint was received from some other person.
Okay,
A complaint was against the husband
okay,
because complainant then never knew that the petitioner has applied for allotment. Allotment was application was filed in 2020, long back, my lord. My application may be seen. Page number 22, my lord.
page
Page 22.
22.
This is application for land allotment for an area of 360,
2020.
2020, my lord. The next page is, this is sketch map.
Okay, what happened? What is, you are agreed by what?
My lord, there's a eviction order. That eviction order has been issued against my husband, but the district administration is going to evict my house. Let's see, my lord, one by one. Page number 23A is a forwarding letter of my application to the government for approval for allotment. Page number 23A, my lord, annexure 4A. It says, my lord, subject, forwarding of sketch map for allotment of land in favor of Miss P. Levy. Sir, I am forwarding here with a copy of sketch map for an area measuring
You read
360.
page 23A.
Yes, my lord. Yes, my lord. May I read it again, my lord?
Yes.
I am forwarding here with a copy of a sketch map for an area measuring 360 square meter located at near Forest Gate of Hapoli Township, John D, along with copy of land allotment application, copy of PRC and ST for allotment of land in favor of Miss Phil Yabin, daughter of Sri Pir Bhat of village Pistana, PO and PSG of Lower Subansiri district. Next para. Therefore, you are requested to kindly convey government approval for allotment of land in favor of Miss Phil Yabin, daughter of Sri Pil Bhat of Pistana village for an area measuring 360 square meter located at
So good notice was issued to you, saying that the land belonged to horticulture department.
yes, my lord. Initially, notice was issued to my husband. Then my husband has made clear that it is not my land, it is land of my wife, and she has already applied for allotment, my lord. That clarification is also there. My lord, kindly see page number 24. This is notice given to my husband. This is the first notice. Then it was replied by my husband. It is in page number 25. Of course, in this reply, he considered himself as landowner. So accordingly, he replied the notice. Thereafter, another
So,
notice,
yes, it was replied by husband only.
yes, my lord.
Then,
Then another notice was issued, page number 27, next page, my lord.
yes.
This was also issued to my husband. Shri Biri
Okay.
Kame.
This was also replied.
This was also replied, but in this reply,
Husband, okay.
next page 28. In this reply, he has made clear that land is not of mine, it is of my wife. And
Now, in the earlier reply,
earlier reply,
he did not say that.
yes, yes.
Okay, now he is saying,
My lord,
so
for,
notice would be issued to my wife.
yes, yes.
And then that is typical.
My lord, let us read
Then
for better
if
understanding.
Notice is issued to wife, then wife will say, now it has gone to husband.
No, no, no. Record is there. I have applied for land allotment. That cannot be changed. My lord, the page number 20, let me read this page number 28. This is reply of my husband. He has said, Madam, with due respect, I would like to state that I have received a copy of
Okay,
notice.
anyway, so what is, you are agreed by now,
I agree by the order of the eviction.
eviction where?
It is page number 40, my lord. Here also, your lordship will find this order has also been passed against my husband.
Impugn order.
Yes, my lord. Page number 40, annexure 15. Page number 4040.
Page
4040, my lord.
40 is the order.
Yes, my lord. May I read? In continuation of this office order number so and so, dated 3rd July 2025, the board constituted therein is hereby directed to carry out eviction of the illegally constructed building within the district horticulture office compound 0. The eviction shall be conducted as per rules with necessary coordination among all concerned members. The executive engineer PW0 shall provide required machinery and logistic support. A brief compliance report of the eviction shall be submitted to the state officer on or before 14th July 2025.
So what
This,
happened thereafter?
this order was,
Evicted, already evicted.
no, my lord, not yet evicted.
So it was to be submitted 4th July, on 4th July, 14th July.
Report has to be submitted on 14th July.
Okay, already submitted.
No, no, my lord. And this, your lordship will find copy 2. In the copy 2, my husband's name is there. Shri Biri Kame for information. My name is not there. So order has been passed for eviction of my husband's property, but the district administration is going to evict my property. My lord. This is an interesting part of this case.
Now see, the order says that within the, you have constructed within the compound of the district horticulture office.
No, my lord,
So
actually,
whether the horticulture office has an allotment.
yes, it has
Then
allotment.
within the allotment, how there can
No,
be
no, my
allotment in your favor?
No, no, my lord, I'll make it clear. My land is outside the compound of the horticulture department.
Then see, the DLRSO as well as the deputy commissioner, after examining, says that this land belongs to the horticulture department.
My lord,
It must come within the allotted land of the horticulture department.
no, my lord, actually,
So
it
if you
is,
claim so, then that becomes a dispute of fact. You have to file
my lord, it is,
that suit.
it is located outside the boundary of the horticulture
That
department.
is why that becomes a dispute of fact.
And they, yes, my lord, I have discussed this matter also in my
Because if
petition.
the horticulture department has the allotment, and if you are claiming that this is outside the allotment, of the horticulture department, then you have to file 30 suits.
My lord, they have proper boundary. And my land is located outside the boundary, my lord.
Now, then why should this deputy commissioner, LRSO and all should say, would say that the land belongs to, it comes under horticulture department, hence this appeal also dismissed, standing in front of sir. Order says, then you file appeal, it appeal, this is appeal.
My lord, one thing,
Hmm.
when I have applied for land allotment,
Hmm.
my land was verified by the district administration. After finding it fit for allotment, they have processed it and they have forwarded to the government for approval, my lord.
But it was rejected, sent back. It appeared.
My lord, yes, sir, it was sent back by observation. Some documents I have not filed. In fact, some of the documents was there. Say they have at the time of forwarding clearly stated PRC was there and the Sinotram certificate was there. But in their written letter, those things are also not available before the directorate. So something is going wrong, my lord, in the directorate office.
Oh, yes,
Lordship have already observed, Lordship, at page 42, while rejecting his application, in observations, Lordship, in serial number 8, ground verification report from DLRSO SK Mandal, it's
Page,
not there,
page.
Lordship, 42, page 42.
yes, all those. Page 42.
This is the main,
Page
Lordship,
42 is some, is a letter.
his annexer, of course, Lordship,
Annexer,
page 42.
page, annexer 17.
Annexer 17. Yes.
Okay, what is this?
Lordship, this is
Relating to return of file.
the
Okay.
while returning the file from direct land
Declaration
management,
of-
director land management,
Ground
to the
verification
commission.
from so and so is.
yeah,
not there.
observation.
Hmm.
In the serial number
See
8,
that-
Lordship will
that
see,
was forwarded.
there was no verification report from
No,
DLRSO
ground
on
verification.
SK Mandal. That
That
forwarding was just a, Lordship,
My lord, the
simple forwarding by someone known officer only, Lordship.
Okay.
Maybe from of the petitioner, Lordship.
my lord,
And
if we
Lordship, this is very clear
if
in
we
the,
compare two documents, my lord,
and
page
it's
number-
clear, the petitioner has no right to claim, Lordship, allotment of government land, Lordship. Whereas this is very much a allotted land of this horticulture department. In the sketch map he have given also, in fourth side, all it is government land, Lordship. And horticulture
Outside
department.
government land. It will be difficult, government.
my lord,
Outside
The
government
side,
land.
how,
my lord,
Not even the road zone.
yes,
let
Lordship.
us see, something is going wrong. If we
Nothing,
compare,
Lordship.
just a second, if we compare two documents, page number 23A, in the forwarding letter, it is clearly stated I have submitted along with the application PRC and ST, but the finding of the directorate office, it shows that PRC, ST and PRC certificate is also required.
No, this is, see, this was forwarded, but then subsequently it was sent back that nothing was there.
My lord,
And see the schedule of the lane. This is
Yes,
even wrote by you only, I think. Government land, all side government land, not even the road. So, not
And-
even the footpath also shown. All side. all
As
side.
your Lordship know, horticulture department, not only the office, Lordship, outside,
Also, you also file affidavit and
allotment
if
is,
the
my
horticulture
lord,
department has the allotment and covering the lane.
Right.
yes, it's not-
Lordship.
okay, you have the horticulture.
my lord,
department.
my lord, allotment is always given from the government land.
Yes, yes,
So
that is true.
all around my land, petitioner's land,
Hmm.
it is a government
But
land.
it has to follow the rules. But then
No,
it
my
appears
lord,
that, it appears that while forwarding your name, nothing was annexed.
My lord,
And
there
this
is
was
a,
just for-
my lord,
sake
there
of
is
it
a,
was
my
forwarded.
lord, there is a government notification,
Hmm.
kindly see.
Could have annexed.
My lord, by this notification, government has regularized land of the many people who has occupied government land. Let me read this
Lordship, this
notification.
was at that point of time only.
Hmm.
This
This
is,
is the-
his application is in 2020, Lordship.
This is of 2012, but this is still valid and enforced, my lord.
No,
Uh,
no, Lord.
Let me read the,
Now see, we have no idea. This notification probably is if the person is in occupation and not being occupied by the government, like horticulture department in the present case. Probably.
well, it is outside the boundary.
Let us see if it is outside the boundary, you have it.
My lord, as per this notification also,
And probably
I am entitled to get land allotment, my lord.
entitled to get.
Land allotment. Let me read my lord.
Lordship,
Let me read this.
petitioner doesn't have a right at all, because
Yeah.
till now, no allotment has been granted.
Hmm.
That clearly states that it's a illegal occupation out there.
Well, let me,
If allotment has been granted, then it would be a different issue. Now, allotment has not been granted, though he has applied but not granted. And this is a.
it is
uh,
under process.
Land of the department.
Prerogative of the government, Lordship.
It is
Will
under
issue-
process.
will issue notice. You file affidavit?
Yes.
Yes.
My lord, in the meantime, interim relief may be.
No,
granted.
interim case.
Mr. Kispoyan, planning council for the petitioner. By this application, under Article 226 of the Constitution of India, the petitioner has challenged, here, where is the impugn order?
My lord, the page number 40.
Okay, eviction order also,
Yes, my lord.
and.
And
which one is
the
prior?
order passed by the Learned Deputy Commissioner, that is page number 38. This is also under impugnment.
Just a minute, sir. Page 38,
38.
this is the order.
This is the order. This is
And
also
where-
under.
This is order passed in the appeal.
Yes, my lord.
Yes, where is the main order?
Main order means this is the order.
Oh, this is appeal,
This is order
section
by
12.
which my appeal
There
has
must be
been
some order.
rejected.
yes.
Order earlier,
32.
Earlier order means
thereafter this was, this is disposal of the appeal filed by you.
before disposal of the appeal,
Page number 32.
Appeal has been disposed of on 36.
32.
06/06/25, my lord.
06. Okay,
Page number
Uh,
32,
the-
32.
eviction order dated 06/06/2025. And the subsequent order dated 30/06/2025 passed by, this was by the Deputy Commissioner.
State absolute.
Hmm?
Order dated 06/06.
No, 36. Well, 06.
06/06/25.
State officer.
State officer. my lord.
Page number, which one?
Page number 32.
32. Okay, no? Order passed by, order dated 6/6/2025 passed by the estate officer, additional deputy commissioner, Lower Subansiri District 0 in no, this is okay, just there is no party, no case registered, just this is order. Okay, then, in number EST, estate, all capital, stroke, sort, the fourth, HORT, dash 1, stroke 2025.
Dated 06/06. my lord.
Okay. And the order dated 30/06/2025 passed by the Deputy Commissioner, Lower Subansiri District 0 in case number AP, all capital, AP stroke 40 dash 1 stroke 2025. Filed by the petition. Whereby the appeal filed by the petitioner under section 12 of the Arunachal Pradesh Public Premises within bracket eviction of unauthorized occupant bracket close act 2003 has been rejected. What else? You are also challenging the order. And also the order dated 8/7/2025 passed by the state officer, Lord Swansea District 0 in number DC-LS-150 29/3/2025. By which the authority directed to carry out eviction of the illegally constructed building within the district horticulture office compound. Issue notice returnable by 4 weeks. Since immediately accept the Lion Senior Government Advocate accept notice on behalf of the respondent number 1, 3, 4 and 5.
Lordship, 1, 2, 3, and 4.
No,
5 is.
2 is also, 2 is I think.
I'm for 5.
You are for 5.
Department.
Okay, 1, 2, 3 and 4. And Mr. Jepson for the respondent number 5. It's a standing counsel for the
Yes.
horticulture department for the respondent number 5. No formal notice needed. However, the petitioner shall furnish requisite extra copy to the respondents during the course of the case. The respondent is allowed to file affidavit. You file affidavit as soon as possible.
Yes, Lordship. We'll file
Within 3
affidavit.
weeks.
Yes, Lordship.
Okay, then returnable by 3 weeks. Okay, returnable by 4 weeks. Least is not after 4 weeks.
Provided we are
Why
funding
not,
copy as soon as Lordship.
But the interim order may be extended. Otherwise,
Because the order is,
Otherwise,
order,
after-
the report must have submitted by now because it was to be submitted with
the
14.
matter
See,
can
this one.
infructuous.
No, if the.
If eviction is carried out, matter will
So
become.
immediately
infructuous.
after, on the returnable date, we'll see, try to dispose
Till,
of,
till returnable that,
because it may, probably in this case, you may be directed to file. Because if the land belongs to the government, if horticulture department has already been allotted, and probably if you are dispute, then probably you have to go to civil court.
why not the till returnable that can be
See,
stayed
the-
in interim order?
Was to be, report was to be submitted with 14 long back.
Yes,
Now we
Lordship.
do not,
Yes,
it must
Lordship.
have already evicted.
No, not
Lordship.
that evicted.
Lordship, I pray that Lordship.
Not
may
yet.
interfere
No,
in
Lordship.
this, Lordship.
Interim cannot be
If,
granted.
if eviction is carried out during the pendency of matter, my lord,
Lordship.
No,
This-
see,
this-
had you come earlier, then could have, but then now you see,
Today is
see
already
that
date.
it was to be, report was to be submitted on 14th July.
my lord,
That means the eviction
no.
has been carried out and then the
But
report also already.
on
submitted.
8 July order was passed, right?
Hmm.
And I was given on 11th.
Hmm.
There was Sunday, Saturday. I had no time, my lord. So At the earliest, I have filed this petition.
Okay, having regard
Lordship,
to the submission
may I
by the
lordship?
Rana Council for petition.
No,
There are
it's
lots of-
returnable that, Lordship. The
The,
interim may be considered if. Lordship.
Till next,
Lordship, records
Okay,
itself
that-
shows that
till next.
land doesn't belongs to him because he has applied for the
you just open
allotment.
instruction, then,
Yes, Lordship. Instruction.
and then on that, they will try to dispose of.
Yes.
Because if the land belongs to the department and then already evicted, no point passing any order also.
But
Had you come earlier, little earlier, at this one day. okay.
no time, my lord. At the earliest I came, I was given only 2 days time. That was some Saturday and Sunday, my lord. At the earliest I have come. Moreover, this court was on vacation, my lord.
Now, the stay order will be difficult at this, otherwise we'll have to give an opportunity to them. to
But till
obtain
next date,
certain-
my lord, if really, if stay is stay not, interim order not stay, my lord, so if they carry out the eviction during the penitentiary matter, this petition will become infructuous, my lord.
Lordship, the whole question
Even-
is
even if-
whether the
even if-
land belongs to the petitioner or not.
They are not going to
Petitioner-
prejudice, my lord.
In the,
It is
in the
provided.
petition itself, he has mentioned that he has applied for the allotment.
The
Meaning that
status
there is
quo-
no-
status
he's
quo
not
of
the
the land as of now shall be maintained if the eviction order has not yet been carried.
Yes,
out
madam.
In person to the
Yes,
order, impugn order dated so.
Yes,
Court. Okay,
Lordship.
if it has not yet been carried out, status quo will be maintained.
yes, madam.
If not yet carried out, according to him, not yet carried out.
Not carried.
But no,
If
Lord-
carried out, it was-
but Lord-
There is no error in passing
Lordship,
this
there
order.
is
also.
no
that is-
prima facie in the.
By
petition
this order,
itself.
Not made
my
of
lord,
any
by
case.
this order, they are not
Because
going to
The
prejudice.
whole question is whether they are the owner or not. They have also applied for
No, you file-
allotment.
You file affidavit showing that the land has been allotted to the horticulture department. Will dispose
We
of the
will
entire-
file on that, but according to their petition, it's clear that land doesn't belong to them as well. Because they have filed for allotment, that means they are not owner of the land.
No, that is true, that is
Lordship
true.
will take instruction
But then
next
what-
Friday without any stay, Lordship.
Hmm?
Without any interim order will.
No, no, order is already
This order
passed.
may be.
Because
This may be
as
taken up on Friday.
Friday,
Lordship.
this
We'll take
Friday, we
instruction.
will
Friday.
take instruction
Yes, Lord.
without.
No.
We'll
No.
take instruction. Lordship.
Order has already been passed.
Then, please, the interim shall be considered on the next day, please it again on Friday.
My lord,
Please.
next Friday.
Yes.
Oblige, madam. Okay.
May it please your lordship.
Yeah.
Well, this, the petition pertains to the promotion to the Arunachal Pradesh Police Service entry grade. Well, despite the rules, well, the posts are filled up 50% by direct recruit and 50% by promotion from the feeder cadre of inspector. And my lord, the rule provided that it has to be amongst the senior most inspector with minimum 5 years of regular service. My lord, I have annexed that RR of 2006, my lord. Amendment. My lord, may I take your lordship to page 20, the operational portion. My lord, by this amendment, clause number 6, by this amendment, clause 12(1)(a) of the mother rules was amended by providing, now may I just read this, Madam?
Yes.
The Departmental Promotion Committee shall consider from time to time the cases of officers eligible under subclause 4 of clause B of Rule 5 who have served in the cadre of Inspector of Police, including Arunachal Pradesh Civil, Arunachal Armed Police Battalion, and Indian Reserve Battalion for not less than 5 years, and prepare a list of officers recommended taking into account the actual vacancy at the time of selection and those likely to occur in the year. The selection shall be made on the basis of merit cum seniority. The Departmental Promotion Committee shall consider from time to time the cases of officers' eligibility under such and such of Rule 5 who have served in the grade of junior administrative grade, entry grade for not less than 5 years, and prepare a list of officers recommending such and such manner. Now, my lord,
In the year 2022 and 23, these rules, 2006 amendment rules was in force. Now, any vacancy, generally, my lord, any vacancy which arose for promotion has to be considered under the provisions of that extant rules which was in force until and unless well, certain difficulty may arise, and in order to remove that difficulty, the authorities may not consider the rules existent then and may go for amended rules. But that is only to remove the difficulty. Otherwise, generally, the settled principle of law is that the vacancy has to be filled on the basis of the rules which were in force when the vacancy arose. Now, my lord, Annex 2 from 24 onwards, my lord, this is the seniority grade. And my lord, our seniority position is at page 30, my lord. Page 30. No. My lord, our name appears in the seniority list. Now, my lord, Annexer 3. Annexer 3, by this, Annexer 3, page 32.
What is page 30 you said?
My lord, my seniority.
Yeah, page 30.
Page, yes, my lord, page,
Appendix 6.
yes, 90, page 30. My lord, petitioner number 1 is serial number 9, then 2, 10, 13, 14, 16, 18, and 20. They are the petitioners here. My lord, from the date of appointment in the present post, inspector, my lord, they were promoted on 25/7/2012. We have been serving as inspector for more than 12 years. As per the RR, we are eligible for consideration for promotion. Now, under these situations, my lord, some vacancy arose. My lord, that is at page 33, but before that, at page 32, Annexure 3, this is a WT message by which regarding promotion from the rank of inspector, civil services and such, well, a request was made to furnish the following service particulars in respect of around 61, around 54 inspectors. And amongst these, the name of the petitioners are here. Number of Annexure 4, my lord. Annexure 4 is very important. My lord, this is the 21.
What is this Annexure 3 you said?
Annexure 3 is the WT message by which the PHQ, police headquarters, asked the SP of every district or the battalion commanders to furnish all the information that is required for holding DPC, particulars, SCR, integrity certificate, and all other.
What is Annexure 4 you said?
Then, my lord, in this list, the name of the petitioners are also included.
Which list? Annexure 4.
Yes. Then Annexure 4, my lord. Annexure 4, my lord. Your lordship has got it. Annexure 4, page 33. Now, my lord, this is a proposal to hold the DPC. This is dated 21/12/2023. May I remember, because these languages are very important. Proposal for conducting DPC for promotion from the rank of inspector to APPS EG, entry grade. I am directed to inform you that so far government has sanctioned 102 posts of APPS EG under Home Department, Government of Arunachal Pradesh. As per the APPS recruitment rules, out of the 102 posts, 51 posts are for direct recruitment and 51 posts are for promotional quota. Out of the 51 promotional quota, 32 posts are filled up. Vacancy of 2 posts occurred due to modification of sanction strength by letter number such and such, letter 11/10/2023, and rest 17 posts fell vacant due to promotion, retirement, death of the following officers. Now, my lord, here 17 persons name is there. There, when the vacancy arose is also specifically mentioned, and this arose in between 2022 and up to 31/11/2023. From this 9/3/2022, when the first vacancy arose, and till 30/11/2023, when the last vacancy arose, the Arunachal Pradesh Police Recruitment Rules 2006 was enforced. Further, Sri such and such will retire from service on 31/12/2023. Hence, 20 posts of promotional quota will fall vacant till 1/1/2024. As per the recruitment rules, 50% posts are to be filled up by direct recruitment and 50% by promotion from Inspector of Police, including Arunachal Pradesh Police, Arunachal Armed Police Battalion, and Indian Reserve Battalion having 5 years regular service in the trade. In the light of the above, I am directed to forward here with the following documents required to place before the DPC in respect of 54 inspectors who have completed 5 years in the grade, with the request to conduct the DPC for considering promotion of inspectors to APPS EG at the earliest. Serial number 1 is service particulars and integrity certificates as Annexure 2. Seniority list. Next page, Malad. Vigilance clearance, NOC, vigilance clearance certificate, property returns. This is issued with the approval of Director General of Police, Arunachal Pradesh. Now, my lord, although this request was made, no DPC was held. In fact, till today, DPC has not been held. Now, my lord, at page 35, under RTI, we have sought the number of vacancies, although this letter at page 33 and 34 is very, very clear. Nevertheless, under this RTI, serial number 2, Malad, number of promotional vacant posts for APPS EG from 1st March 2022 to December 6, 2023 is 19 posts. The reply is 19 posts.
So
Now,
this 19 posts is to be filled up from
amongst the inspector of the
entire 19 or 50%?
Yeah, 19. 19 is the promotional post. 19 is the promotional quota. This post.
This is promotional quota,
Yes,
not 50%.
not 50% direct.
Yes,
Because
the recruitment rules, 50% posts are to be filled up by the direct recruitment and 50 by promotion.
By promotion. So these are
It is 50% only then.
these are all they have occupied this post from the promotional quota only.
No, according to you, these 19 posts is to be filled up by way of
This is
recruitment, 50% by way of recruitment and 50% by promotion.
promotion. This is promotional quota. This 19 comes within the 50% promotional quota.
Okay, so there is a creation also.
Yes. This is the vacancy position.
Total post is 34, sorry, 38,
32.
32.
Yes.
Then 32, 16 should be the for promotional 16 posts.
Out of these 32, these 19 posts fell vacant.
But out of 32, 19 posts.
Fell vacant because of the retirement or promotion or death. Those who were occupying the post of Deputy Superintendent of Police, SDPO,
Okay.
or
Yes, yes.
Assistant Commandant, they were all promoted, either promoted,
Okay.
and these
promotional quota has to be filled up on the basis of the common seniority list, which I have annexed at Annexer 2, my lord. And my lord, in Annexer 6, page 36, this is a office memorandum issued by the Department of Administrative Reforms, Government of Arunachal Pradesh.
So, annexer,
6, page 36,
page
36.
26.
Now, my lord, this OM, basing on the Government of India notification and other circular, it provided that the DPC should be held minimum 2 times in a year.
Where do we find?
Let us come to direct serial number 4.
Yes.
Let us come to page serial number 4. Then 1. Departmental Promotion Committee DPC meeting shall be held for promotion of officials who come under the zone of consideration during the month of January to June, the first week of July of the particular year. Departmental Promotion Committee shall be held for promotion of officials who come under the zone of considerations during the month of July to November, the first week of January of the succeeding year. Now, this is the norms for holding the DPC. Now, my lord, on 10th April 2025, I mean, till that, no DPC has been held to fill up this 19 vacant post. And in fact, today, more vacancy has arose. But then we are concerned about this 19 post, which fell vacant in the year 22 to 23. Now, in the year 2025, on 10th April 2025, the government has adopted another amendment rules, that is 2025 rules, my lord. Now, under these amendment rules, my lord, at page 39, you start from 38. My lord, I have, let us see the typed out copy.
April.
Yes, 46 is, I will take your lordship to amendment of rule 5, clause 6. The type portion is at 46, my lord. Page number 46.
Yes.
Now, my lord, here, my lord, we have not assailed this RR. We will be filing another batch of petitions either tomorrow or day after tomorrow, challenging the virus of these provisions. My lord, here, what they did is, they have calculated the position of the inspectors, and they have worked out amongst the inspectors how many inspectors are from the civil police, how many are from the FPP battalion, and how many are from the IRBN. And since the inspectors in the IRBN constituted only 15.35%, this promotion was reserved for 15.35%. Whereas, as per the schedule to these amendment rules, well, you will may come back to page 42. Page 42, start with page 41, my lord. This is the schedule, part A. Part A. Page 42, my lord. Serial number 52 to 58. Now, my lord, here, these are all above 51, up to 51 is civil police. Assistant Commandant
First APPBN 6 post. Assistant Commandant second APBN is 6 post. Assistant Commandant IRBN first IRBN 7, second IRBN 6, third IRBN 7, fourth IRBN 7, fifth IRBN 6. That's how in the assistant commandant or in the entry grade, there are 12 posts reserved for the battalion and 33 for the IRBN. And by applying the 50-50%, this will come to 6 for the IRBN, for the APP battalion, and 17 for the IRBN. Now, these 2025 rules, by making this percentile system, as per this 53 point, these are the sanctioned posts. This C12 and 33 are the sanctioned posts under this rule, part A, schedule of this part A, page 42, Malad. Now, if we come to this, 15.35% will consider only out of the 17, it will come to only 9 posts. And 0.25% for APPN. This will come only to 3 posts. And whereas for IRBN, it is 17 posts, and for APP battalion, it is 6 posts. Now, I'm just highlighting this because if this 2025 rule is applied to fill up this post of 19 vacancies, we will be getting only 8. 4 is already occupied, only 4 will be considered. And battalion also will only 1 will be considered. Now, as I've submitted, my lord, is only to show that how prejudiced we shall be. But the virus of this act, of these provisions, we will be challenging in under writ petitions. Now, my lord, my respectful submission is authorities has a right to amend the rules, but that cannot be to the detriment of the right that had accrued to us. In the year 2022 and 23, when this vacancy arose, a legitimate right had accrued to us. Had that post been filled up by holding regular DPC, these writ petitioners, along with other eligible inspectors, would have been considered for promotion. Maybe we would have been promoted.
Whether the government is taking state now.
Now, only 3 will be considered from the IRBN by applying this ratio. So therefore, my respectful submission is there is nothing.
As per the new RR.
Yes, as per new RR. Now, my lord, now as I have submitted, my lord, generally the post which fell vacant during the currency of rules has to be filled up on the basis of the provisions of that rule. The new rule cannot be applied retrospectively. Having said that, my lord, if there is some certain difficulty, and in certain difficulty in applying that provisions of the earlier rules in making the promotion, then in order to remove those difficulty, a new system may be adopted, and then that can be considered. But those situations are very rare and exceptional. Generally, the post has to be filled up on the basis of the rules that was prevalent at the time when the vacancy arose. So, my lord, I've been informed that the department, after this enactment of this amendment rules, they are trying to fill up this 25 posts, including some others. I think there are about 30 or 27 posts. So, my lord, my respectful submission is this is this. Some interim notice may be issued, yes, and interim or maybe provided, my lord.
My lord,
Praying for interest.
similar nature of writ petition was earlier filed. My lord will kindly come to page 30. Page 30, my lord. 30 is
Yes.
the petitioner in this writ petition is serial number 9, 10, 13, 14, 16, 18, and 20. Now, my lord, earlier writ petitioners, my lord will find Milo Roja is serial number 11. My lord will see the cost title of the order. Milo Roja, serial number 11.
In the
Mil
order?
Yes, my lord, in the order, front of the order itself,
Okay.
the array of parties.
Serial number?
Milo Roja, serial number 11. My lord, in the name of the parties,
Okay.
number 1, Milo Roja,
Okay, yes.
he is in serial number 11.
Hmm.
Number 2, Mintor Kino, he is in serial number 12.
Milo Roja is also petitioner here in this.
No, my lord.
Okay.
These are earlier same means litigants, my lord, from the same inspectors, my lord. Serial number 2 is Mintor Kino.
2.
Yes. Then Kaing Earring is at serial number 15.
Yeah, 2 is Mito Kino is
In 12.
12.
12.
Okay. Hmm.
Same sets of litigants, my lord. Then Kaing Earring is serial number 15. Here, serial number 15.
Hmm.
Kaing Earring.
Hmm.
Then number 4, Tadar Nachung is serial number 17. Tadar Nachung, my lord, will find at serial number 17. Milo Roja is
Okay. Yes.
Kaing Earring, my lord, will find at serial number 15. Then Tadar Nachung, serial number 17. Michi Sambio. Bedum Borang at serial number
19.
19, madam. 5 litigants, they from the same group, they have already approached this honorable court.
Hmm.
My lord, there was no stay granted, my lord. By this order, the petitioners they were allowed to implead the private respondents who are supposed to be the beneficiaries to be impleaded as the party. That was allowed and no interim was granted. My lord will kindly see what the court observed, my lord. In the last para, having considered the fact that the newly implemented respondents have been allowed to file their objection to the interlocutory application, and also considering that the process of DPC normally should not be stalled, and no interim order is called for at this stage. However, in view of the pendency of the application, same may be considered on the next day. This was the order, my lord. Now, coming to the merit of the case. The prayer is the simple legal issue involved is that they are praying that they should be considered as per the RR, the old RR, because the vacancy arose during the existence of the old RR. This is the legal point they are urging, madam. Now, this legal point, madam, has been already settled, madam. This legal point earlier in Rangia's case, it was held that yes, the post should be filled up at, when the vacancy arose as per the existing RR. That was the law laid down in Rangia's case. But this Rangia's case has been overruled by now. I'll just place the citation, my lord. Just for short, my lord, I'll take your lordship to para 13, the same issue. Para 13, that will be at page 787. Issue, my lord. Para 13, the real question is whether the vacancies which arose prior to the promulgation of the new rules are to be filled only as per the old rules and not as per the amended rules. It is argued that this principle is no more res intrivia, as the Supreme Court recognizes such a right in Rangia's case. And it has been followed in a large number of subsequent decisions. A list of such judgments was forwarded to the court by the respondents. On the other hand, while submitting that there is no such right, an even larger list of decisions of this court that distinguish Rangia's case was forwarded to us on behalf of the state. Now, we have taken note of the facts that there are large number of decisions that have either followed the principle of Rangia's case, saying that all rules will be applicable when the vacancy arose, or have distinguished it that new rules after the amendment, what rules will, even if the vacancy arose during the existence of the old rules, if it has not been filled up. Now, after coming of the new rules, it has to be filled up as per the new rules. That has been the law laid down recently, madam, subsequent to madam. Now, I'll not bother. The relevant portion, madam, paragraph will be at page 817, paragraph 82. 817, an analysis. After many judgments, looking into the old judgments that were placed before by both the parties, madam. A review of 15 cases that have distinguished Rangia's case would demonstrate that this court has consistently carving out exceptions to the broad proposition formulated in Rangia's. The findings in these judgments that have been have a direct bearing on the proposition formulated by Rangia's case are as under. There is no rule of universal application that vacancies must be filled on the basis of law which existed on the date when they arose. Rangia's case must be understood in the context of the rules involved therein. It is now a settled position of law that a candidate has a right to be considered in the light of existing rules, which implies the rule in force as on the date consideration takes place. The right to be considered for promotion occurs on the date of consideration of the eligible candidates. The government is entitled to take a conscious policy decision not to fill up vacancies arising prior to the amendment of the rules. The employees does not acquire any vested right to being considered for promotion in accordance with the repeal rules in view of the policy decision taken by the government. This is very clear, madam. There is no obligation for the government to make appointments as per old rules in the event of restructuring of cadre is intended for efficient working of the unit. The only requirement is that the policy decision of the government must be fair and reasonable and must be justified on the touchstone of Article 40. The principle in Rangia need not be applied merely because posts were created, as it is not obligatory for the appointing authority to fill up the post immediately. Where there is no statutory duty cast upon the state to consider the appointment to vacancies that existed prior to the amendment, the state cannot be directed to consider the cases. The above referred met in the 15 decisions that have distinguished Rangia's demonstrate that the wide principle enunciated therein is substantially watered down. Almost all decisions that distinguish Rangia's hold that there is no rule of universal application to the effect that vacancies must necessarily be filled on the basis of law that existed on the date when they arose. This principle only implies that decision in Rangia is confined to the facts of that case. The decision of so-and-so is a complete departure from the principle of Rangia in as much as the court has held that candidate has right to be considered in the light of the existing rule. That is the rule in force on the date of consideration that takes place. This enunciation is followed in many subsequent decisions, including the date of union of so-and-so, 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 held that there is a right to be considered for promotion in accordance with rules which prevail on the date on which the consideration for promotion takes place.
We'll continue.
Yes, ma'am. May I please? Hello. My lord, we were in para 84 at page 818.
Yes.
May I read, my lord? The decision in Deepak Agarwal's Agarwal is a complete departure from the principle in Rangia in as much as the court has held that a candidate has a right to be considered in the light of the existing rule. That is the rule in force on the date of consideration takes place, madam. This enunciation is followed in many subsequent decisions, including that of the Union of India versus Krishna Kumar. In fact, in Krishna Kumar, court held that there is only a right to be considered for promotion in accordance with rules which prevail on the date on which the consideration for promotion takes place. The consistent findings in these 15 decisions that Rangia's case must be seen in the context of its own facts, coupled with the declarations therein that there is no rule of universal application to the effect that vacancies must necessarily be filled on the basis of rules which existed on the date on which they arose, compel us to conclude that the decision in Rangia is impliedly overruled. However, as there is no declaration of law to this effect, it continues to be cited as a precedent, and this court has been distinguishing it on some ground or the other, as we have indicated herein above. For clarity and certainty, it is therefore necessary for us to hold. Now, what it holds that the statement in YB Rangia versus Srinivasa Rao that the vacancies which occurred prior to the amended rules would be governed by the old rules and not by the amended rules does not reflect the correct position of law governing the service under the Union and the states under Part 14 of the Constitution. It is hereby overruled. My lord, Rangia's case has been overruled. The rights and obligations of persons serving the Union and states are to be sourced from the rules governing the services. Now, therefore, the very prayer in this writ petition, the my lord will kindly see the prayer portion, says that the vacancy, my lord, the prayer is at page 15, 14, my lord. What the first prayer itself, issue an appropriate writ, order or direction declaring that the 19th post of Arunachal Pradesh Police Service, which arose in the year 22 and 2023, is to be filled under the Arunachal Pradesh Police Amended Rules 2006 and not under the Arunachal Pradesh Police Service Rules 2025. This is the basic prayer, meaning thereby, since those vacancies arose prior to the amendment, so it has to be filled up as per the old rules. This is the basic prayer. Now, by this judgment, the main prayer itself cannot be granted, my lord, because the Honorable Apex Court has said that the candidates will be have a right for promotion to be considered for promotion as per the existing rules, not as per the old rules. This is the only legal issue, whether to fill up as per the old rules or fill up as per the amended rules. Now, law is clear, my lord. So, today, my lord, at this stage, I'll say that it is not at all maintainable, the prayer is not maintainable now. But even then, if my lord fails to issue notice, then notice can be issued. But however, there, as in the earlier set of writ petition, in that writ petition also, there were certain candidates who were called through WT message to fill up, to submit their applications. And those candidates were not made party in that writ petition. So by filing an IA, they were allowed to implement them as a party, those private respondents who are going to be affected. And at this stage, no interim to withhold the process of DPC, my lord. Law is very clear, my lord.
The application of the decided law has to be also done on the basis of facts. My lord, in Rajkumar case, the factual matrix is distinguishable. The language itself is that Rangaya case is not universally applicable. That itself gives a room that Rangaya case is also applicable in certain
Whether the
cases.
government has taken steps to.
Well, I'm just coming. Malad. In Rajkumar case, what happened is in the year 2006, the government of Haryana, they created 6 posts of labor officers, but they did not start any recruitment process until the 1966 rules were amended by the new rules, and only after amendment they have started the recruitment process. And in that context itself, it's some persons they have approached that it should be recruited under the 1966 rules, and the High Court of Haryana has upheld applied the Rangaya case, which the Supreme Court has held in Rajkumar that this is not universally correct, because the recruitment process started after the new rules had come into existence. Now, in my case, my lord, may I again take your lordship to Annexure 3, the WT message. Your lordship, let us come to Annexure 3 and 4. The recruitment process has already started.
Recruitment for the entry grade.
Yes, on promotional, my lord, promotion is also one source of recruitment only. Under Annexure 3, this is dated 14/11 to 2023. The police headquarters, in order to fill up this 19 posts, had sought the records of the eligible candidates, in which the name of the petitioners were also included. And Annexure 4, my lord. Annexure 4, this is dated 21/12/2023. This was received in the Home Department by diary number 865, dated 22/12/2023. Now here already let us see the last two paragraphs. Last two paragraphs, my lord. May I read? As per the recruitment rules, 50% posts are to be filled up by direct recruitment and 50% by promotion from Inspector of Police including Arunachal Pradesh Police, Pradesh Armed Police Battalion, and Indian Reserve Battalion having 5 years regular service in the grade. Copy of the RR is indicated as Annexure 1. Now, these 2006 RR was the Annexure 1. In the light of the above, I am directed to forward here with the following documents required to place before the DPC in respect of 54 inspectors who have completed 5 years in the grade, with the request to conduct the DPC for considering promotion of inspectors to APPS EG at the earliest. Now here they have collected all the documents, 6 sets of documents, 6 different sets of documents. Now, it is only for the Home Department to convene the DPC. Otherwise, this process has already started. And now, when the process has already started under the 2006 rules, can the rules be changed? Can the game be changed when the play has already started? This is not a permissible, my lord. The respondent authorities cannot change the rules when the game has already begun. Now, my lord, the Supreme Court in Test Prakash Pathak versus Rajasthan High Court decided on 7 November 2024 has categorically held that the rule of the game cannot be changed in the middle of the game. That would be totally arbitrary and illegal. Well, may I just take your logic to in a handwritten, I have given the paragraph page number 5. Page number 5, paragraph 7. The law is settled that the commencement of the recruitment process, the eligibility criteria is not to be altered because candidates, even if eligible under the altered criteria, might not apply by the last date under the belief that they are not eligible as but as criteria. Such alteration, change, therefore, deprive a person of the guarantee of equal opportunity in matters of public employment provided by Article 16 of the Constitution. The reference order therefore acknowledged his legal position and in clear terms accept that the rules of the game cannot be changed after commencement of the recruitment process insofar as eligibility criteria is concerned. But in any form, the rule of the game cannot be changed in between. Now, I would like to again take your lordship to page 7 also. Here's a certain observation, page 7, paragraph 13 and 14, and then paragraph 17. The process of recruitment begins with the issuance of advertisement and ends with the filling up of the notified vacancies. It consists of various steps like inviting application, scrutiny of application, rejection of defective applications or elimination of ineligible candidates, conducting examinations, calling for interview or viva voce, and preparation of the list of successful candidates for appointment. Well, this talks directly about the direct recruitment process, but then in our case also,
initiation of the
but in our case also, since
process by inviting in,
yes, therefore, my lord, the promotion process has already started by issuing the WT message and by writing to the government, the department or Home Department for conducting the DPC. Now, and relying on the 2006 rules. And when the process has started, can the government now, after more than 15 months of this was the 21/12/2003, today is July, 21 July, exactly 1 year, 7 months. After 1 and 7 months, I have come to your lordship, and they have waited for 15 months. And in the meantime, they have changed the rules. Is it permissible, my lord? No, my lord, at this stage, my only prayer would be that let the DPC be directed not to be held for just for a few days, and we will have a throughout full-fledged hearing on the merits of this case and on the application of this Rajkumar case also, because the factual aspect is different. And that also says that Rangaya case is not universally applicable, but that does not say that Rangaya case, the law settled there, has been totally obliterated. Because that was based on that.
Whether the government has taken any steps for recruitment, new recruitment as per this 2025 rules.
Now, the minimum rules is page 45. Now, another aspect is these 2025 rules, it does not provide that this will be made effective retrospectively, or that any vacancy that has arisen earlier under any rules shall be filled up in terms of these 2025 rules. There is no such provisions. And when there is no such provision, that this rule shall apply to any post having fallen vacant earlier, and that this will be effective retrospectively. So it cannot be applied retrospectively. This has to be prospective. All the rules are by nature, it is prospective. So therefore, my lord, this is totally a fit case wherein your lordship shall interfere. And in my ground also, I have categorically stated, because of the inaction of certain officers under ulterior motive, my right, which is legitimate expectations, legitimate right, cannot be deprived.
Mr. T. Patu, counsel for the petitioner.
I appear for 1 to 4. One to 4.
Just because you have made a prayer, whether the government has taken any steps for issuance of any advertisement for recruitment of the entry grade in terms of this new RI.
I think I have heard that they have immediately, and that also, my lord, within 1 day, they have sent this thing, requisition. They have obtained all the vigilance report 1 day, in 1 day. So, my lord, my submission is this post has not been filled up for the last 17 months. And the heavens will not fall if it is not filled up for another few days. So, my lord, let us have either my repetition should be allowed or dismissed. So, my lord, until now, supposing if this is filled up on the basis of 2025, then my repetition shall become infructuous. It is not that I do not have any case. I have a legitimate expectations. That legitimate right accrued when this vacancy arose these legitimate expectations and right accrued when the WT message was WT message records were called for, and this accrued when proposal for holding DPC on the basis of the 2006 rules were sought to be held. So that right, that legitimate right cannot be extinguished now.
By filing this application under 226 of the Constitution of India, the petitioners, how many, 6 direction to the respondent authority to immediately hold the DPC by setting a time frame and consider the case of the petitioner for promotion to the post of Arunachal Pradesh Police Service within the entry grade and fill up the identified vacancies from 9/3/2022 to 30/11/2023, including the 2 posts created on 11/10/2023 by way of review DPC for the period from 1/1/2022 to 31/5/2022, 1/6/2022 to 31/12/2022, 1/1/2023 to 31/5/2023, and for the period from 1/6/2023 to 31/12/2023. It is a case of the petitioner that they are governed by the RR governed by the 2000, governed by the notification, sorry, governed by the Arunachal Pradesh Police Service Amendment Code 2006, and therefore the 19 vacancy posts which arose between 9/3/2022 to 30/11/2023 be filled up as per the RR, as per the Arunachal Pradesh Police Service Amendment Rule 2006. And not under the Arunachal Pradesh Police Service Amendment Rule 2025. Issue notice. Returnable by 4 weeks since Mr. M. Ratan, Land Additional accepted notice on behalf of the respondent number
1 to 4.
to 4. No problem of this meeting to say respondent.
Or no, extra.
The petitioners, however, the petitioner will furnish exclusive extra copy to the Land Council and additional item. The petitioner shall take steps upon the private respondent.
No private
No
response.
brother.
No private. So who is this? Okay, this is petitioner. Okay, all the respondents from 1 to 4. Okay. Then
Since my lord, same category of petitioners, they were not granted interim, my lord, only notice may be issued.
No, my lord. In that case, they are going to hold the DPC on the basis of 2025
There-
rules. We will be prejudiced.
In fact, they cannot claim the existence of legitimate expectation after the Rangia's case has been overruled. It has been overruled by this Rajkumar's case. Now, that legal right no more exists now. Question of, in fact, this is a fit case to be dismissed at the motion stage. That very right has gone, man. It says the rules will be applicable, the new rules will be applicable at the time of consideration of for promotion.
That argument is not valid, my lord. They have changed the rule of the game.
It is
During the
changing the rules of the
time.
game is in context with the direct recruitment process.
They have not recalled the WT message. They have not recalled the 21/12/2023 letter.
Where is the,
My lord,
which paragraph?
overruled.
Hmm.
Yes, my lord, paragraph,
So where the new rules should be followed?
my lord,
Where it says that the new rules should be followed. This is overruled.
my lord, I will come to para 85.1.
Okay.
The statement in RV Rangia versus so-and-so,
Okay.
that
Why-
the vacancies which occurred prior to the amended rules will be governed by the old rules and not by the amended rules.
Mr.
This
And-
statement does not
and-
reflect the correct position.
Just Mr. Endratan Danet AG, additional AG, for referring to the decision in the state of Himachal Pradesh and others versus Rajkumar and others. Some instance, the vacancy vacancies which occurred prior to the amended rule would be governed by, sorry, just governed by the old rules and not by the amended rules has been overruled. In the whole case. Our Mr. Patil, some is that. Since the process for holding DPC has already begun in the year.
But I will also rely on another citation.
Hmm.
That's holding that amendment is always prospective.
And since the rule of the game has already begun, cannot be changed after commencement of the, it cannot be changed.
The paragraph 9 of this.
Hmm? Paragraph?
Oh, no, but another adjustment. The rules are
Another-
prospective in nature.
And the rules are prospective. The rules are always prospective in nature. Be that as it may.
paragraph 9. Further, my lord, the facts in Rajkumar case and in our case, the facts can be distinguished. In that case, posts were created, but no recruitment process is started. And it was, rules were amended, and thereafter only the recruitment process is started. Under that background only, that observation was made. And in our case, already recruitment process started.
My lord, I have given the citation to the point. It is not a dispute that rules are always prospective. Rules cannot be changed when the game has started. These are propositions of law, but in another context.
So is it your case that the process for new recruitment has started?
No.
Okay.
This is that proposition of law that changing the rules of the game when the game has started, that is for a direct recruitment case. Now this,
recruitment, even
here
DPC is also recruitment.
yes, DPC is also a mode of recruitment, but it is a promotion and the game will start only when the consideration starts. It's not for calling of the consideration. When the consideration starts,
Appointments are not.
when the DPC starts,
There are other means of appointment.
when the DPC starts, then the game starts. Calling for their qualifications are just like warm up.
Considering that the process for DPC has already begun in the year 2023.
The date may be mentioned on 21/12/2023.
On 31?
21/12/2023.
21/12/2023. It is provided that pendency of the present writ petition would not be barred if the 19th post of Arunachal Pradesh Police Service entry grade arising in 2022-23 is filled up under the Arunachal Pradesh Police Service Amendment Rule 2016. No bar.
No bar. Yes.
2006 rules.
Yes.
Obliged.
Made page lordships.
Yes, please. Yes.
Lord, the present petitioner is the, my lord, distributor of Arunachal Pradesh State Lottery. My lord. Now, paper book is big, but my lord, the subject matter is small.
So actually, I was looking for that.
Yes.
Synopsis.
Lordship,
I had no time, so I was looking for the synopsis. I couldn't find. Which is there?
it starts at page A, Miller.
Oh,
Page A. Well, I'll go very slow, Miller. I'll
it is
explain.
not.
Huh?
Synopsis is not in the petition.
Page A, Miller.
Yeah.
A. After the index. Page A.
No. No, after index.
WPC 316 of 25, Miller.
Yes. It is not there.
A. Page A. Can I just find out, Miller? Huh? No, it is there, Milord. Page A. After the index,
Index is there, and then there are immediately the petition starts.
wait, huh? তোমার ইতিহাস দিলে কেনেকে হব? Hmm? Can I use this copy? Please. Yes. Milord, I'll go very slow, Milord. Now, Milord, petitioner is the distributor of Arunachal Pradesh state lotteries, Milord. Now, there is a central act, Milord, that Lottery Regulation Act of 1998, which governs, Milord, how a lottery would be conducted. Now, there is a concept called state organized lottery. It is a state organized lottery. State may itself do the business, or state may conduct the lottery through distributor. Here in this case, Milord, not only state of Arunachal Pradesh, many other states who are in the business of doing state organized lottery, they either do themselves or they appoint distributor. Now, petitioner is the distributor under the state of Arunachal Pradesh. Now, my lord, earlier different tax regimes were there. With effect from July 2017, GST regime came into force, my lord. Under the GST regime, my lord, now lottery is a destination-based consumption tax. It's a destination-based consumption tax. Now, my lord, the issue which is involved in the present case is the state of Arunachal Pradesh lottery, that is, which is being conducted through the present petitioner, and the lottery which are being sold not in the state of Arunachal Pradesh, but it is being sold in the state of Punjab and Maharashtra. Therefore, it is in the course of interstate trade and commerce under the IG Integrated Goods and Service Tax Act, Milord. This tax is to be paid in the state where the recipient of the service, Milord, received the benefit. So here in this case, it is Punjab and Maharashtra. Yes. Then, Milord, what had happened, this is the third round of litigation before this honorable court within the month of June and July. First, what had happened, Milord, a criminal complaint was filed against the director and the chief executive operating officer of the company, alleging violation of section 208 of the BNS, where, Milord, cognizance was taken and summons were issued. Then we approached this honorable court stayed those proceedings. Thereafter, Milord, they wanted to register us under GST and State Act in the state of Arunachal Pradesh. Challenging that, we filed second writ petition, where this honorable court has clearly recorded a finding that the commissionerate at Arunachal Pradesh is not the proper officer because it has got no territorial jurisdiction. Therefore, this proper officer is the officer sitting in Punjab and Maharashtra. Therefore, court said no coercive measure. Despite that order, now what they have done, Milord, they have passed an order of suo motu registration under the CGST Act and the State Act, and Milord, they have also issued a show cause notice. Now, the present writ petition has been filed assailing, Milord, the suo motu registration order and the show cause notice. Now, we are challenging this order basically on two grounds. One, the commissionerate at Arunachal Pradesh has no jurisdiction. They have absolutely got no business. And secondly, my lord, there is abuse of the process of authority. Because we are already registered. under the state of Punjab and Maharashtra, and already we are paying IGST. Now, just to give a details of the proceedings, my lord, let me place 2-3 proceedings, then everything will be clear. My lord will kindly have this act, Goods and Services Tax. Do you have this act? Huh? No. Two, three provision, my lord. Actually, I can go in details, but I'll limit my submission, my lord. First, my lord will kindly come to section 9(3), subsection 3 of section 9. Pages will not tell you. Pages may not tell you because Lordship is holding another case. If Lordship would kindly come to section 9, levy and collection. Well, there are 3 acts. One is Central Goods and Services Tax, other is Arunachal Goods and Service Tax, and third one is Integrated Goods and Service Tax. Now, ours is a case which falls under the IGST Act because it is in the course of interstate trade and commerce. Therefore, my lord, we are paying tax in Punjab and Chandigarh. There is no requirement of paying tax in, my lord, state of Borno. Otherwise, it will amount to double jeopardy. Now, please come to section 9. Subject to the provisions of subsection 2, there shall be levied a tax called Central Goods and Services Tax, all on intrastate, that is transaction which takes place within the state. Supplies of goods or services or both, except on the supply of alcoholic liquor for human consumption and undentured extra neutral alcohol or rectified spirit used for the purpose of alcoholic liquor for human consumption on value determined under section 15 and at such rate not exceeding 20% as may be notified by the government on recommendation of the council and collected in such manner as may be prescribed and shall be paid by taxable person. So my lord, lordship knows in every taxing statute there is a provision, charging provision. This is the charging provision as we understand it, normally understand in taxing statute parlance. Now please come to 3. This is important. The government may, on recommendation of the council, council means, my lord, GST council. I may just pause here for a moment, my lord. GST council is a authority, is an entity which is envisaged in the constitution itself. It is the highest body under Article 246 capital A and 279 capital A. Because when GST was introduced, my lord, there were amendments in the constitution whereby this GST council was envisaged. And it is the highest body. And here, my lord, Union Finance Minister is the chairman and state finance ministers of all the states are also members. It is they who decide from time to time because it's a new regime, my lord. So they from time to time take a call regarding how tax should be levied, what all are the measures to be done. And they will also from time to time, if they find any demerits in any system, they try to rectify that and so on and so forth. So let me read subsection 3. The government may, on the recommendation of the council by notification, specify category of supply of goods or services or both. The tax on which shall be paid on reverse charge basis by recipient of such goods or services or both, and all provisions of this act shall apply to such recipient as if he is the person liable for the tax in relation to supply of such goods or services or both. My lord, lottery, let me make it one thing very clear, my lord. Lottery per se, it is not a good. It is called, my lord, actionable claim. What is that? It's nothing, my lord. It's a piece of paper. In the event of winning a prize, I have a claim over something. That's why it is called actionable claim. Even under the regime prior to GST also, my lord, there are definitions are there. So there is no dispute that lottery is an actionable claim. So what we find from subsection 3 is, my lord, when tax is payable on reverse charge, then it is the recipient of the service who will pay the tax. Am I clear, Lordships? So subsection 3 of section 9 envisages a situation where it is the recipient who will pay tax. And this will, my lord, not be in the intra-state trade, my lord. It will be in the course of interstate trade. Subsection 1 emphasizes intrastate, where if it would have been an intrastate transaction, then they would have been right. Since it is a transaction in the course of interstate trade and commerce, state of Arunachal Pradesh or the commissioner in Arunachal Pradesh has absolutely no authority. It is without jurisdiction. Now, my lord, will kindly come to section 22. There are notifications issued under it. I'll come little later. Section 22. Now, the heading is registration, chapter. Just to give an idea of the, my lord, subject matter, I'm placing it. Otherwise, my lord, by virtue of the other two orders, I'm covered as far as interim period is concerned. Kindly see, my lord. Persons liable for registration. Every supplier shall be liable to be registered under this act in the state or union territory, other than special category states. Now, this is very significant, my lord. From where he makes a taxable supply of the goods or services or both. Am I clear, my lord? When it comes to registration, what is the requirement? From where he makes a taxable supply of goods. Now, please come to section 23, my lord. Section 23, subsection 1 says these are the persons who are not liable for registration. We are not concerned with subsection 23(1). We are concerned with subsection 2. Notwithstanding anything to the contrary contained in subsection 1 of section 22 or section 24, the government may, on recommendation of the council by notification, subject to such conditions and restrictions as may be specified therein, specify the category of persons who may be exempted from obtaining registration under this act. So, my lord, notwithstanding section 22(1), what subsection 2 of section 23 says is, my lord, that on the recommendation of the GST Council, then a category of persons may be exempted from application of the act. Am I clear, my lord? I'll come to the notification issued under 23(2) little later. Let me also read 24(3), my lord. Compulsory registration in certain cases. Notwithstanding anything contained in subsection 1 of section 22, following categories of persons shall be required to be registered under this act. Please come to 3, my lord. Persons who are required to pay tax under reverse charge. So we are required to be registered. There is no dispute. The dispute is whether in state of Arunachal Pradesh, under the CGST and State Act, State CGST Act, or under the IGST Act in the state of Punjab and Maharashtra. Am I clear, my lord? It is not our case that we are exempted from registration. It is the state of Arunachal Pradesh who is exempted by the notification. But as a distributor, I am liable to be registered under IGST in the state of Punjab and Maharashtra. That we are done. Then, my lord, will kindly come to section 25. Procedure for registration. Now, this clarifies section 22(1). The procedure for registration. Every person who is liable to be registered under section 22 or section 24 shall apply for registration in every such state in which he is so liable. Now, legislature could have used the expression, my lord, in the state in which it is, my lord, registered or exists. Why does the legislature say in which he is so liable? I am not liable to pay GST in the state of Arunachal Pradesh. Well, this officer, this commissioner who has undertaken all this exercise, He has been indicted by Bombay High Court, my lord, for doing exactly similar situation. I'll place that judgment. But he has been indicted literally, my lord. My lord, he is fishing in a territory where he is not supposed to. He is abusing his authority. I'll show, my lord, how our advocate, how our chartered accountants were detained without any authority of law after the order of this honorable court. So, my lord, in which he is so liable. He is liable in the state of Punjab and Haryana. We have paid, my lord, 48.13 crores. Then, my lord, come to subsection 4. A person who has obtained or is required to obtain more than one registration, whether in one state or union territory or more than one state or union territory, shall, in respect of each such registration, be treated as a distinct person for the purposes of this act. So as I have to be treated as a, to be registered under that act, where, my lord, I am liable to do so. I can't be compelled to take registration in the state of Arunachal Pradesh when I am not doing any interstate business. All that I am doing is an interstate business. My lottery tickets are being sold in, my lord, Punjab and Maharashtra. Now please come to subsection 8 of section 25. Who is the authority? It is the proper officer. How can he be the proper the officer of the Commissionerate of Arunachal Pradesh is not the proper officer. This is already a finding of this honorable court. Where a person who is liable to be registered, I'm sorry, my lord, subsection 8 of section 25. The sentence starting with where a person is a long section, my lord. Subsection 8 of section 25.
Yes.
Has your lordship got it, my lord? Yes. Where a person who is liable to be registered under this act fails to obtain registration, the proper officer may, without prejudice to any such action, which may be taken under this act or under any law for the timing in force, proceed to register such person in such manner as may be prescribed. Supposing in an appropriate case, my lord, supposing we are required to be registered in the state of Arunachal Pradesh, then it is the proper officer. Now, who is a proper officer? It is defined, my lord. Please come to the definition. Since I am harping on the point of jurisdiction part, that it is all these actions are without any authority. That's why, my lord, this definition assumes importance. 291, subsection 91 of section 2. Proper officer in relation to any function to be performed under this act means the commissioner or the other officer of the central tax which is assigned that function by commissioner in the book. Let the other side show notification where in case of, my lord, interstate trade, the commissioner of a particular state has been authorized. Let them produce that. End of the day, there has to be an assignment by the board, my lord. Board will assign not to him, court is not assigned to him. Then, my lord, will kindly come to, there is in the same very book, my lord, lordships will find the IGST Act. These are the provisions of the Central Goods and Services Tax. Now, please come to IGST Act, section 10. Integrated Goods and Service Tax Act 2017. Section 10, my lord.
Section
10 of the IGST Act. Has your lordship got it, my lord? Place of supply of goods. Can I find out for your lordship?
230.
Lordship got it, my lord? Yes. Section 10.
Yes.
Yes. Please come to A, my lord.
Just a minute.
Section 10. Integrated goods and service. Actually, my lord, in this, normally in these books, there will be Central Goods and Service Tax Act and Integrated Goods and Service Tax Act. Lordships can have this book, my lord. Page number 138.
138.
এখন उसमें नहीं है क्या? उसमें है.
No, not 70. Okay.
Page 138, my lord. হয় নে? Section 10.
Yes.
Yes. This is very important in our case, my lord. Place of supply of goods other than supply of goods imported into or exported from India. Where the supply involves movement of goods, whether by the supplier or recipient or by any other person, the place of supply of such goods shall be the location of the goods at the time at which movement of the goods terminates for delivery to the recipient. Since, my lord, we as a distributor of the state of Arunachal Pradesh is not selling our lottery tickets within the state of Arunachal Pradesh, we supply it to the, my lord, state of Punjab and Maharashtra, where the concerned person receives it, and the, my lord, what do you call it? Movement of the goods terminates in the state of Punjab and Maharashtra. Huh?
Is the printer and common supply.
Yes. And, my lord, most importantly, these tickets are printed in Haryana. I'll come to from the show cause notice itself, I'll show, my lord. So, end of the day, these tickets are being sold in the state of Punjab and Maharashtra. So, in terms of section 10(1)(a), my lord, it is in the course of interstate trade and commerce. Therefore, this transaction with which we are concerned is covered by section 10(1)(a), read with the relevant notifications of the government of India. I'll come to their notification little later, my lord. Am I clear to this extent, my lord? They want to say that we are covered by CGST and Arunachal Goods and Service Tax here. And we say, and therefore we should pay tax here. We say no. We are not selling out. They acknowledge the fact that we are not. I'll show from the show cause notice below. But they say you will have to pay here also. Well, this is nothing but arbitrariness. Well, then senior officer, he should understand what is the implication of this act. He has already been indicted by Bombay High Court. Now, my lord, I'll place the two notifications and one decision of the, my lord, GST Council that your lordships will get at page number 489. 489, my lord. Second volume, my lord. There are 3 volumes. Lordships will kindly take. It starts at 449, my lord. In fact, the very first page of volume 2. Kindly see, my lord, on top. Minutes of 28th GST Council meeting held on 21 July 2018. Am I clear, my lord? Now please come to 289. 489, I'm sorry, 489. Clarification may be issued towards the bottom, my lord, at page 489. Is very important in our case. A, if organizing state, that is Arunachal Pradesh, is registered in the state in which organizing state's lottery is being sold, all has a fixed establishment there, then supply of lottery by organizing state to lottery distributor or selling agent is an intra-state supply on which CGST, SGST of the consuming state is to be paid under reverse charge by the lottery distributor. So this is not the situation in our case. Am I very clear, my lord? That's why there the word used is an intrastate supply. We are covered by B. Kindly see, my lord. If the organizing state is not registered in the state in which organizing state's lottery is being sold or does not have a fixed establishment there, then since distributor selling agent will necessarily be registered in the consuming state, so and so, requirement in so and so, framed by the state government under section so and so, transaction at first point of distribution chain between organizing state government and the lottery distributor shall be an interstate supply on which IGST is to be paid under reverse charge by the lottery distributor, which we are doing, my lord. Ours, the organizing state is Arunachal Pradesh. The tickets are being sold in the state of Punjab and Maharashtra on reverse charge, therefore IGST is payable, which we are paying. Now, my lord, this is a fact which is acknowledged by the authority that I'll place, my lord. My lord will kindly come to page number 88 of the writ petition, my lord, first volume. It's a part of the show cause notice, which we have challenged here.
Page 88.
Yes. Page 88, my lord. Now, my lord, Lottery Department of State of Arunachal Pradesh was issued a notice. Page 88 of the volume 1, my lord. It's a part of the show cause notice. Show cause notice starts at page 79. I'll have your lordship's kind attention to para 4.19. Under Secretary of the Lottery Department voluntarily appeared on 18/6/25 to subscribe a statement as requested before. Therefore, a spot summon dated 18/6/25 was issued and statement dated 18/6/25 was recorded, in which inter alia the following relevant facts and documents were supplied. Kindly similar. Supply of lottery ticket is taxable to GST, but lottery department don't need to get itself registered under GST for supply of lottery tickets, and GST payable on lottery tickets are duly being paid by noticee. Noticee means the petitioner on behalf of the government of Arunachal Pradesh. So the government of state government's, stand is very clear that on our behalf, it is the noticee, that is the petitioner, who are paying the applicable GST. Now, my lord will kindly come to page 84 of the same notice. Sorry, page 82, my lord, I'm sorry.
83.
Page 82, my lord. And let's see D on top. After C, D. The noticee sell weekly draw lotteries in the state of Maharashtra and Punjab, and bumper lottery tickets are sold in Sikkim and West Bengal. So it is the case of the GST department itself that we sell our lottery in the state of Maharashtra and Punjab. So if I am selling my lottery ticket in Maharashtra and Punjab, how do you assume jurisdiction? How you are the proper officer? You are harassing people. You have no business to harass people like this. Then my lord will kindly come to page 84. Because there was an issue of unsold tickets. That the lottery ticket at page 84, Miller, para B. That lottery tickets are printed by New Tax Security Printers Haryana approximately 3 to 4 weeks prior to the date of the draw, The maximum number of tickets that can be printed for each draw is specified by the government in the lottery scheme. The actual number of tickets to be printed is determined by the noticee based on market demand. The noticee communicate this requirement to the government of Arunachal Pradesh, who then instruct the printing agency accordingly. So, everything is regulated by the provisions of the Lottery Regulation Act and the central rules of 2010. So, everything. If there are unsold tickets, 1 hour ahead, we must inform the state government that these are the extent of the unsold tickets which have remained. Therefore, that cannot be accounted for. Now, will kindly come to page number annexure 28. Page number 28. Annexure 28. If your lordships will, I have to trouble your lordships, Milord. If your lordships would kindly come to the third volume, it starts at 1110, annexure 28, Milord. They should not have tagged it together because it becomes inconvenient to handle, Milord.
Yes.
Please come to annexure 28, page 1110. This is the statement, Milord, of the tax we have paid for that intrastate trade. Now, if your lordships will kindly see the columns, Milord, it starts from, this covers the entire period which is under so-called investigation by the GST authority. That is July 2017 to, Milord, May 2025. Now, if your lordships would kindly come to column number 1, 2, 3, 4, 5, 6. 6 column, Milord, Arunachal Pradesh paper lottery. Has your lordships got it, Milord? Yes. Now, Milord will kindly come to page number 1116. That's the last page of that annexure. 1116. Now, if your lordship would kindly count 6, Milord. 1, 2, 3, 4, 5, 6. That's the column AP. 48 crore 13,000 we have already paid. Now, who are you to raise this, Milord, register us, and Milord again, then it will be double taxation. We have already paid 48 crore 13 lakhs. And for the entire country, we have paid 33,000 and odd crores. If we take note of all the lotteries we conduct, Milord, during this relevant period, we have paid to the Government of India GST to the extent of 33,000 crores. Now, Milord, I'll place 2 notifications, Milord, which will make the position absolutely clear. If your lordship would kindly take the third volume for a moment, Milord. At page 821. Because, Milord, that statute says council will say. Now, the council has, GST council has said, kindly see, Milord. At page 821, it is notification number 4 of 2017. In exercise of power conferred by subsection 3 of section 9, the first provision which I read, the central government on recommendation of the council, that is GST council, hereby specifies supply of goods, the description of which is specified in column number 3 of the table below, falling under tariff item, subheading, heading or chapter, as the case may be, as specified in the corresponding entry in column 2 of the said table, made by the person as specified in corresponding entry in column number 4, in respect of which central tax shall be paid on reverse charge basis by recipient of the intrastate supply of goods as specified in the corresponding entry in column 5, and all provisions of the said Act shall apply to such recipient. My lord, this is a situation where it is referring to that intrastate part. Now, if your lordship will kindly come to 822. Kindly come to serial number 5, my lord, supply of lottery. Then extreme right hand side, lottery distributor or sole selling agent. So it is the recipient who is liable to pay. This is a case where, my lord, we are concerned with intra. Now the other notification lordships will get at page number 987. In exercise of the power conferred by subsection 2 of section 23. My lord, subsection 2 of section 23 is the provision which says, notwithstanding anything contained in section 22, which mandates registration, my lord, there could be exemption. Now here it is said, in exercise of the power conferred by subsection 2 of section 23 of the Central Goods and Services Act, the central government hereby specifies the person who are only engaged in making supplies of taxable goods or services or both, the total tax on which is liable to be paid on reverse charge basis by recipient of such goods or services or both under subsection 2 of section 9 as the category of persons exempted from obtaining registration under the Act. My lord, in my humble understanding, subject to what your lordships may say, my lord, the purport of this notification is state of Arunachal Pradesh is exempted. But the, my lord, distributor is not exempted. The distributor as a recipient in the area, in the state in which he receives, my lord, there he is required to be registered and pay tax. As has been reflected from the, my lord, page 1116. We have already paid the tax for these transactions, my lord. And my lord, Shokos also recognizes the fact, as I have already read page 82, 84, and my lord, page 88. Now, my lord, this is the conduct of the commissionerate in the Arunachal Pradesh. They were trying to usurp the powers of some other authority. Now, kindly see, my lord, what are the orders passed by this honorable court in the earlier 2 rounds of litigation. If your lordship should kindly come to page 729, my lord, in the 3rd volume. I may just briefly indicate, my lord, why we had to file this writ petition. What had happened, my lord? A complaint was filed purportedly under section 208 of the BNS, which is bailable, which is also non-cognizable, my lord. That's warrant of arrest were issued, my lord. And they were insisting, my lord, that the director of this company, managing director of this company, my lord, who has suffered a severe brain stroke, has almost become, my lord, vegetable, my lord. Now they are insisting on his personal appearance. When the Act and the other provisions of the statute, my lord, says there could be representation also. These are all malafide, my lord. This has only misuse of power. Now, my lord, this please come to, my lord, page number 638 first, then I'll place the order, my lord. Page 638 in volume, 2nd volume, my lord. $638, my lord.
383.
Yes, 2nd volume. Yes, it's the prayer in the first petition, my lord. In the complaint, I'm sorry, in the complaint. In the premises stated above, it is most respectfully prayed that your honor would be pleased to admit the criminal complaint against S. Martin and Vilas Khatiwara, and after examining the complaint, records and after hearing the parties, your honor may be pleased to issue warrant of arrest under section 72 of the BNSS and may kindly be issued by the Honorable Court against Martin and Vilas Khatigora as detailed at cause title above, immediately by treating urgency since it is a time-bar procedure and they are evading the government revenue, and the same may kindly be directed to be executed through appropriate police authority in terms of so and so. So this was the prayer made in the complaint petition, my lord. Then, my lord, and it was a bailable case and it was non-cognizable, my lord. Now, my lord will kindly come to the order passed by this honorable court when cognizance was taken. We move this honorable court, page 729 in the third volume, my lord. चाहिए तो same volume में है. Sorry, my lord, in the same volume, second volume. Second volume at page 730. Page 730. May I have your lordship's kind attention to the second subpara. Sri so-and-so learned senior counsel by referring to the various provisions of the GST Act, IGST Act, as well as BNS, BNSS, submit that GST authority does not have jurisdiction as petitioner's company, although is an authorized distributor of state of lottery. They are selling the lottery only in the state of Maharashtra and Punjab with valid registration, registered in the state of Tamil Nadu. Therefore, notices summons by GST authorities without jurisdiction, and as a sequel, the criminal complaint and the orders passed by the judicial magistrate and summons after taking cognizance of the alleged offence under 209 of BNS is absolutely the jurisdiction and not in accordance with law. Then kindly come to the order, my lord. First subpara. Considering that petitioner's company, although is an authorized distributor of state of Arunachal Pradesh lottery, the selling of lottery is only in the state of Maharashtra and Punjab with GST registration in the state of so-and-so. The notices summons issued by GST authority in the state of Arunachal Pradesh. The complaint being so-and-so filed by GST authority based on which summons are issued. I am inclined to stay the orders that is so-and-so. So from this order, three distinct things emerges, my lord. First thing is that we are a distributor of the state lottery, that we are selling the lottery tickets in the state of Punjab and Maharashtra, and that we are paying GST in the consuming state. So after this, where is your jurisdiction? Now, this is the first writ petition, my lord. Then, my lord, what they did? And secondly, my lord, there is one more thing. Page 731, just to show the, my lord, malafide. Please come to the last para. However, considering the issue being pertains to GST, it is directed that petitioners shall appear before the GST authority through their authorized representatives on 26/6/25 in response to notices by GST authority. So we said, my lord, number one is ill. Number two has other difficulties. Therefore, it said this honorable court permitted representation. Now, lordships will kindly come to the, now what they did in the meantime, in spite of the fact that this order was passed, whereby the, my lord, issue of jurisdiction was gone into, and prima facie this honorable court recorded a finding, they wanted to, my lord, proceed in the matter and register our unit in the state of, under the CGST Act and the Arunachal Pradesh GST Act. It is at that stage, my lord, we filed the second writ petition, which your lordship. Then what happened, my lord? Yes, I forgot to point out one thing, my lord. That order was passed on 26/25. This order which I have read, my lord. On 26/6/25, my lord, armed with the order dated 26/25, this chartered accountant and advocate for the petitioner went to the office of the authority. Naturally, this honorable court said our representatives can go and attend to them. So when they went, my lord, on 27/6/25, this chartered accountant of the petitioner company was shown arrested. Eventually, my lord, he had to be released on bail, passed by the judicial authority, my lord. And whole overnight they were detained, my lord, inhumanly treated. And my lord, now we'll kindly come to page number 732, just to show the mala fide, my lord, at volume 2. Arrest memo, 732. Whereas the principal commissioner Shyamkanu Mohanto has reasons to believe that you, Ayush Agarwal, that is our CA, my lord, authorized representative, aged so and so, have committed an offence specified in clause A or clause B or clause C or clause D of subsection 1 of section 132 of Central Goods and Services Act, which is punishable under clause 1 or 2 of subsection 1 or subsection 1 or subsection 2 of this 8th section. My lord, I'll just refer to 132.1. My lord will kindly see how he has abused his authority. Kindly have a look, my lord, just to appreciate, my lord, how the position has been misused, my lord. Please come to section 132 in the book, my lord. Kindly, page number 101, my lord. 101. I am a chartered, the person Ayush is a chartered accountant. Kindly see, my lord, whether he has committed offense under 132.1 A to B. Whoever commits 101, my lord. 132. Whoever commits or causes to commit and retain the benefits arising out of any of the following offences, namely, supplies any goods or services or both without issue of invoice in violation of provisions. Well, will a chartered accountant of a particular petitioner firm or a lawyer will indulge in selling goods without invoice? Kindly see, my lord, the extent of arbitrariness. Issues any invoice or bill without supply of goods, avail input credit, collects any amount as tax but fails to pay the same to the government. Under these offense, my lord, I was arrested. Kindly see, my lord. He has committed criminal offense. Have I sold any goods without any invoice? Have I appropriate to myself any tax which I should pay to the government? These are the offense, my lord. I have taken your lordships to this provision just to show, my lord, the extent of malefides this officer. I'll come to the order of the Bombay High Court and the Supreme Court. Then, my lord, what happens? Oh, yes, next page is 733. 733. Now, though this order has been issued by, my lord, some other officer, but the power to authorize is the commissioner. Kindly come to the last para. Now, an investigation was initiated against Future Gaming, which entered into an agreement with Department of State Lotteries, Government of Arunachal Pradesh for procurement and distribution, etc., etc. The company received lottery tickets via delivery challans without tax invoice, declared only net sold ticket under SOEM and did not issue self invoice as required under so and so. 733, Miller. Yes. Now, first para, wherein Ayush Agarwal, son of Sri so-and-so, has been associated with Future Gaming in the capacity as authorized signatory. In his statement recorded before the Assistant Commissioner, CGST, Central Excise, Itanagar Commissioner, he admitted to being authorized signatory of the firm and acknowledged his role as a chartered accountant. If I am chartered accountant, I have no other responsibility, responsible for handling company's GST affairs, he actively involves in so and so. Pursuant to the power conferred under section 69(1) of the CGST Act, my lord, this conferment is given by the commissioner, Shyam Kanu Mahanta, though it is issued by somebody else. The purpose of drawing your lordship's kind attention to page 733 is the memo of arrest, ground of arrest, etc. Everything was done under the supervision and authority of the commissioner, Shyam Kanu Mahanta. Am I clear, my lord? Now, to show, my lord, how he is misusing the authority. Then, my lord will kindly come to the bail order. Page 737. In fact, the last page of volume 2, my lord. When the chartered accountant was produced before the learned judicial magistrate, my lord, first class, this was the order passed. Please come to page 738. First subpara. After careful perusal of the case record, bail application, and Honorable High Court's order dated 26/25, I am of the considered view that grounds of arrest shown by the IO are not justified, and therefore I am of the considered opinion that to release the accused person on the following condition. The grounds of arrest are not germane, my lord. Thereafter, my lord, he was detained, he was kept in the office. Then thereafter, what they did, my lord, then we moved the second petition, my lord, when they were going ahead with the, process of issuing a registration certificate and show cause. That order, lordships will find at third volume, my lord, page 978. This is very important, where a clear recording finding has been recorded that the present commissioner is not the proper officer. My lord will kindly come to page 980. I will not read the whole order. That operative portion. The last but one subpara sentence starting with considering, as the lordship got in there. Considering that the petitioner, though distributor of state lottery of Arunachal Pradesh, as they are selling the state lottery in other states and paying the required tax, kindly mark this word, very important. After registration under GST and paid the minimum guaranteed revenue to the state of Arunachal Pradesh and respondent number 2 and 3, appears to be prima facie not the proper officer. So what more is required, my lord? If they are not the proper officer, they cannot register us. They cannot issue the show cause notice. Now they have issued a suo motu registration order and show cause notice, which we have challenged, and that too in the intervening night. This order was passed on 30th, my lord. At night they passed the order. After this order. Before this order, sorry. Intervening night of 29 and 30. So, my lord, this is the case. Now what they have done is, please come to page 77 and 79. First volume. Page 77, my lord. Order of grant of temporary registration, suo motu registration. This is what is under challenge in this case. Whereas undersigned has sufficient reasons to believe that you are liable for registration under the Act and therefore you are hereby registered on temporary basis. On, my lord, same date, 36/27/5, this Honorable Court in WPC number 291 of 25 has recorded a finding that you are not prima facie, you are not the proper officer. So, my lord, this is an abuse. And secondly, my lord, there are other limb of arguments on this. The moment you say there are reasons to believe, my lord, end of the day, this is always justiciable, my lord, because this is your subjective satisfaction. And this subjective satisfaction should always be based on some objective material. What are the objective material? your past wrongdoings, which was taken note of by the Bombay High Court and the Supreme Court of India. Now, what are those? And where is the notice? I'm just not making this argument, my lord. Then at page 79 is the impugned show cause notice. Draft. Page 79, this is the show cause notice. They have raised the demand of 98 crores. I do not know what is the basis. They have also taken note of unsold tickets. Anyway, my lord, these are on the merits of the case. I'm not troubling on lordships at this stage. Now, I'll show my lord how he was indicted by the judicial authority, my lord. हाँ दे दीजिए पेज हम बता देंगे ना दे दीजिए नहीं फर्स्ट बॉम्बे नहीं शांतनु My lord will kindly come to compilation दीजिए हाँ दिखा दो पेज बोलो पेज बोलो पैरा 18 My lord will kindly come to page number 1078, my lord. We have annexed that order. Annexure number 26. Page number बताइए. It starts at, my lord, page number 1078, my lord. Para 18 कहाँ है? Para 18. On the other hand. Please come to page 1091, my lord. This is the same officer, my lord, Shyamkanu Mohanto. Para 18. On the other hand, has a lordship got it, my lord?
Yes.
Mr. Sharma, learned counsel for the respondent, has made submission supporting the impugned show cause notice. He relies on the reply affidavit of Shyamkanu Mohanto. At that point of time, my lord, he was Additional Director General of Ahmedabad Zone, and now he is the Commissioner here in Arunachal Pradesh. So, my lord, I have referred to this para to refer to the stand of the same gentleman in a proceeding before the High Court, my lord. Then, my lord will kindly come to para 32. Please come to page number 1105. Exactly same situation, my lord, where he wanted to usurp jurisdiction and what the Honorable Bombay High Court said, my lord. And this order was appealed by Union of India. Supreme Court dismissed the SLP. Para 32. For the aforesaid reason, it is clear from the relevant content of the show cause notice that basic jurisdictional requirements are not attracted for issuance of a show cause notice under section 74 of the CGST Act. Here also a show cause notice is under 72 and 74 of the CGST Act. So as to inter alia invoke 122(1)(a) and section 137 against the petitioner. My lord, 122(1)(a), this proviso was added sometimes in 2023. It doesn't even cover the period. Even otherwise, it is ill-conceived to read and recognize into the provisions of section 122 and 137 of the CGST Act any principle of vicarious liability being attracted. There could be none. Thus, the respondent number 3 clearly lacked jurisdiction to adjudicate the show cause notice in its applicability to the petitioner. Thus, qua the petitioner impugned show cause notice is rendered burden. This is on merit. Now come to his conduct, my lord. For the foregoing reasons, the foregoing reasons would also lead us to conclude that it is highly unconsignable and disproportionate for the concerned officer of the revenue to demand from the petitioner an amount of rupees 3731 crore, which is in fact clearly alleged to be a liability of so-and-so Marsec, as the content of the show cause notice itself would demonstrate. The petitioner would not be incorrect in contending that purpose of issuing show cause notice to the petitioner, who is merely an employee, was designed to threaten and pressurize the petitioner. So, my lord, the view which was taken by the Honorable Bombay High Court was that this ploy was adopted to put pressure, my lord. So, my lord, this is this judgment we have placed for two purposes, my lord. First, a similar jurisdiction was sought to be usurped when Bombay High Court intervened. Then Union of India filed an appeal, my lord, that was rejected, which your lordships will get at page next to page, my lord. Page बताइए 1107, my lord, para 4. The issue before the High Court was one relating to interpretation of section 122(1)(a) and section 137 of the GST Act. The High Court, after assigning cause and reason, took the view that respondent herein was merely an employee of the company and he would not have been fastened with the liability of 3731 crores. We see no good reason to interfere with the common impugned judgment and order passed by the High Court. So, my lord, Union of India went in appeal to the Supreme Court. Supreme Court dismissed the SLP. Now, there is one more case, my lord, that is page number 25. Compilation. One judgment, my lord, one paragraph. Now, it starts at page 136, my lord. Sorry. Page 136, it starts, my lord. Please come to page 138. Para 4. Now, kindly see para 4, my lord. I'll read just 2 lines just to show he was the same very person who was involved in this case. After receipt of notice of the present petition, Mr. Shyamkanu Mohanto, Deputy Commissioner of Customs, Jawaharlal Nehru Custom House, has filed a detailed affidavit in response thereto. This is only for the purpose of showing the same gentleman was involved in this case. Now, what had happened in this case, my lord? Lordship knows all these revenue intelligence on all. They rely on information provided by some persons, my lord. And there is a scheme of the government which money is never audited, my lord. They pay. Now, here in this case, my lord, certain vital informations were provided by the informer. And the reward which is envisaged under the scheme of the Government of India, which was not being paid to him. It was in that context, certain scathing observations were made that I'll place, my lord. Yes, at this very officer. Please come to page, my lord, 141. My lord, the line about 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. Line about 14 from top, my lord. A sentence starting on the right hand side. On this background. On this background, we fail to appreciate the stand taken by the Deputy Commissioner of Customs in his affidavit that they were already in receipt of the information sometimes in January 2010 and they were acting upon the said information and therefore the petitioner is not entitled for the balance of the reward amount. We are at pains to note that though a specific stand was taken in the affidavit that since January 2010, the respondent department was in receipt of specific information, it is not disclosed that what prevented them from acting on the said information swiftly. In our considered opinion, officers who were in receipt of the said information but failed to act upon is a matter of serious concern and also a matter of investigation for the higher authorities. Then my lord will kindly come to that page 143. Sorry, I'm sorry, same. The affidavit of the Deputy Commissioner of Customs in unequivocal terms admits that the petitioner provided information on 19th of July 2010 about imports of consumer goods by concealing them in 5 containers, and based upon the same action was taken against the said container. It is worth to, anyway, my lord, the gist of the allegation is that despite providing information, the rewards were not paid on some untenable ground when court had to intervene. Then my lord will kindly come to page 143. On top, my lord, third line. We find on the right hand side, page 143, my lord. we find that the stand taken by the respondent department is against its own interest, promising someone to bring forth the tax evasion with an allurement that he would get certain reward, and thereafter retracting on a hyper-technical ground and trying to play with the words to dissuade the citizens from bringing to the notice of the sales tax department the evasion of taxes by the SEC. So this has got nothing to do with the merits of the case, my lord, just to show from time to time how this commissioner has been abusing his authority. Only for that limited purpose, my lord, we have brought to your lordship's kind notice these aspects. My lord, I'm conscious of the fact that I am moving a motion. I'm not doing a hearing. But my lord, to sum up, my contention is very simple. I am engaged in the business of state organized lottery in the capacity of a distributor. Though I am a distributor of the state of Arunachal Pradesh, my lord, we do not do any business of selling those tickets in the state of Arunachal Pradesh. Therefore, CGST Act and Arunachal GST Act has no application, it being not a transaction in the course of intra-state trade and commerce. On the contrary, my lord, the tickets are printed in the state of Haryana. It are being sold in the state of Punjab and Maharashtra, where we are registered. We are paying taxes, which I have already indicated. And my lord, under the scheme of the Act, more particularly the Constitution Article 246A, read with 279, it is the GST Council who plays a pivotal role in the administration of this regime, my lord. And in terms of the provision of Section 10(1)A of the IGST Act, I am registered, I am paying tax, because it is the place where it is the recipient, where the movement ends, where the recipient good receives the goods, that is the place where I am supposed to pay the tax, which I am paying. And GST Council is the highest authority, and GST Council has laid down in the notifications which have place. Therefore, my lord, where is the scope? I subjecting myself to the CGST and Arunachal Pradesh GST authority in terms of this registration and this show cause notice. I may indicate to your lordships, my lord. Otherwise, the other two matters are fixed on next 28. So therefore, my prayer is, my lord, lordship will stay this show motor registration order and the show cause notice and fix the matter on 28. And show cause notice, my lord, tomorrow is the date. And my lord, there is one more thing. Under Section 75, if any stay order is operating, then that period can be excluded. So therefore, no prejudice will be suffered by anybody. Therefore, GST authority cannot say, if you grant stay, then our will be prejudiced. No. Just have a look at Section 75 for a moment, my lord. If any stay order is passed, that will be excluded. Section 75, general provision relating to determination of tax. Where service of notice or issuance of order is stayed by an order of a court or appellate tribunal, period of such stay shall be excluded in continuing the period specified in subsection 2 and 10 of section 23, etc. etc. So they have already, rightly or wrongly, they have issued a show cause notice. Ultimately, if they succeed, then they will proceed. But at this stage, prima facie, my lord, this honorable court having already recorded prima facie satisfaction in two earlier proceedings that the GST authority at Itanagar is not the jurisdictional authority, my lord, it will be highly improper to permit them to proceed with the proceedings. Therefore, I will pray, my lord, these two notices at page 77 and 79 should be stayed, my lord, until further orders. And these two matters can be tagged with the other two writ petitions, my lord. That is, my lord, the two writ petitions are, my lord, 281 of 25 and 291 of 25. So that is my humble submission, my lord. I reserve my right of reply, subject to what my learned friend for the department says. I'm deeply obliged.
May lordship.
Yes.
I'm appearing on behalf of this respondent number 2, 3, 4, and 5 and 6. So, here actually, Lordship, I like to apprise in this motion stage also, if this notice may be issued, that will be good. But to reply all those things, and if that has been stated, then the remaining those procedure will be left, since the genesis of this case arises from one investigation case. So in inquiry and investigation, may Lordship please may turn same barrack, that same barrack, in same barrack, page number 189. Page number 189. Rule number 16. So reason for suo motu registration is there in this Rule 16. May I read this Rule 16? Where pursuant to any survey, inquiry, inspection, search, or any other proceedings under the Act, the proper officer finds that a person liable to registration under the Act has failed to supply for such registration, such officer may register the said person on temporary basis and issue an order in Form GST Registration 12. So subsequently, rule number 3, that this subsequent next 3, every person to whom a temporary registration has been granted under sub-rule 1 shall within a period of 90 days from the date of the grant of such registration submit an application for registration in the form and manner provided in Rule 8 or Rule 12, provided that where the said person has filed an appeal against the grant of temporary registration. In such case, the application for registration shall be submitted within a period of 30 days from the date of the issuance of the order upholding the liability of registration by the appellate authority. Lordship, what I mean to say is that they were supposed to file appeal against that suo motu registration, and therefore at this stage it's bound to be dismissed at this stage, because they need to be directed and they need to appear before the appellate authority. They are not exhausted that authority. So based on this, the reason for suo motu registration is that during the inquiry officer has found that, for example, as practice in Arunachal Pradesh, like lottery department is like a PWD or RWD department. They are giving some tender work to someone like L1. Like same goes, future gaming got L1 in this lottery distribution, almost same. They got L1 and they started distributing those things. And as per the record, lottery is being drawn here in under the Department of Lottery, under the control of Under Secretary and Director of Lottery, Secretary Office. Stamp, seal and stamp and everything is of state government. So as per the Section 9 of Section 9 Rule 5 of CGST Act, it's there in page number, Lordship. So 19, same barrack. The government may, on recommendation of the council by notification, specify categories of service, the tax on intra-state supplies of which shall be paid by the electronic commerce operator if such service are supplied through it, and all the provision of this act shall apply to such electronic commerce operator as if he is the supplier liable for
You are reading
Yes.
provision
5.
5.
Yes. But they're bound to or deemed to be as a supplier on behalf of the government only. So they are bound to pay reverse charge mechanism tax over here. And as per the data, everything, whatever they allege the officers are not doing anything else subject to the digital record. Because everything record are drawn through digital data. That's a GST web portal. Through that, they got all the data. And based on that, they are bound to pay 98.43 crore to this. This is the revenue of the state and central government. So they are evading. And in this regard, they have been asked to appear before the investigating officer, but they had evaded because they were supposed to submit all those documents. For example, agreement document with the department. For example, the lottery, total lottery from 2018 onwards till date. And as for the section 73 of this CGST Act, it's a time-bound recovery because it needs to be recovered within 5 years. So that's the reason they have evaded subsequent summon. So as per the one notification in 2022, if those taxpayers, they evade those summon, then for their appearance, the officer need to file a criminal complaint before the jurisdictional magistrate. But that's the reason that officer has approached the jurisdictional magistrate for the appearance of that person. In that first order, it was not arrest warrant, just notice was issued and they were asked to appear. But subsequently, they challenged as per the 281 of WPC 2025. And based on that, we were also expecting if he appeared, then there is no requirement of that criminal complaint also, as per the officer. So once they appear, that case is almost infructuous because we were expecting we need only those documents only, Lordship. Otherwise, nothing is there in this case. And later on again in WPC 291, subsequently, they moved before the Honorable High Court by stating that this inquiry in the investigation in this CGST office need to be stayed. Subsequently, Lordship had clearly observed that, okay, it's a only inquiry because there is some prima facie cases there. And it's economic offense, where in economic offense, there's a preponderance of probabilities there. And as per the data record, they were bound to pay tax. But they're contending that they are not bound to pay over here and they're not bound to register over here. But as per the Rule 16, which I read, Rule 16, the inquiry officer, after finding, they can do the suo motu registration. And subsequently, that suo motu registration has been registered. Thereby, to challenge this suo motu registration, they need to file appeal before the appellate authority, not before this High Court, Lordship. So they can appeal there, and it's only 26 days only. It's 90 days available. So they can file appeal before the appellate authority, since they have not exhausted their remedy.
Who is the appellate authority?
Appellate authority is there is a chief commissioner.
Same person. Same person. Malab, this argument was made before the Supreme Lordship knows Whirlpool Corporation's case. When Malab, this bar of alternative remedy, that aspect was dealt with. 3 situations, my lord, where then authority exercises jurisdiction when it has none, where there is violation of fundamental right, where my lord, there is violation of rules of natural justice, and lastly, if any provision of a statute is challenged, then there is no question of appeal. My lord, under the GST, relying on Whirlpool, my lord, this judgment was rendered in civil appeal 5393 of 2010.
Lordship, all the statement has been recorded by the IO of those there.
And my learned friend is talking of Rule 16, and Rule 16 also speaks of proper officer. Who is proper officer? Your commissioner or the person there?
Now that
My lord will
itself
kindly
is-
have para 6, my lord.
so that itself is in dispute
One
now.
second, one second. Since you have raised that.
Yes.
Para 6, my lord. Page 7, para 6. At the end of last century, this court in paragraph 15 of its decision reported in so-and-so carved out the exceptions on the exercise existence whereof a writ would be justified in entertaining, a writ court would be justified in entertaining a writ petition, despite the party approaching it not having availed the alternative remedy provided by the statute. The same reads as under, where writ petition seeks enforcement of any fundamental right, where there is violation of principles of natural justice. Now 3, where the order of proceedings are wholly without jurisdiction. So my lord, in this situation, the bar of existence of alternative remedies never entertained, my lord. My lord, end of the day, my lord, 226 is the inviolable basic structure of the constitution, my lord. For example, your lordships would recollect when Administrative Tribunal Act was enacted, then my lord, the jurisdiction of high courts were taken away. It was said in the earlier provision that against the order of Central Administrative Tribunal, appeals would lie before the Supreme Court. Initially, a 3-judge bench of the Supreme Court in Sampath Kumar said no, it's okay. Then the matter was referred, my lord. L. Chandra Kumar, when Supreme Court says no, High Court's power under 226 cannot be taken away by any statute. It's a different matter, my lord. It's a self-imposed limitation which a High Court exercises in an appropriate case. Where there my lord, some factual inaccuracies are there. Here we are questioning your authority to initiate this proceeding. If you do not have the jurisdiction, why should I go to the from Caesar to Caesar's wife? And the appellate authority is the same commissioner. Therefore, my lord, these arguments,
Lordship,
better my learned friend file an affidavit and
Yes.
justify his action.
Lordship, that's why regarding WPC 281, we are that and 291, that affidavit in opposition we are filing, and subsequently in this regard also. So therefore, if it's been stated, it's not the loss of other people, it's the loss of the government only, revenue only.
No, no,
And
revenue
it's
may pay.
it's on record, and whatever they are paying, their lordship need to understand their forward charge are there. Forward charge mechanism is something different, and reverse charge mechanism is something different. And they're earning from state of Arunachal Pradesh, and they're not paying any penny to anyone, and just they had made one agreement with department. That's like giving bribe to someone, lordship. They're bound to pay here. So even though GST law itself is very pragmatic and dynamic, it's very new also. There are numbers of issues are coming up now.
They are not paying anywhere means,
State of Arunachal Pradesh.
no, but they are paying there.
That's record has not given to us till date. Lordship.
Now
Now
they themselves say, I'll show my lord.
they
And the state has admitted. Page 88, my lord. I've shown it. Page
lordship
88, please come to page 88 for a moment, my lord.
they are bound to pay over here. So that's the issue. From one day only.
Making submission like a child. He's clamoring for a chocolate. It can't be, my lord. Statute does not say I should pay here. Page 88, 4.19. Kindly see, my lord, A. That it is the stand of the state of Arunachal Pradesh. The supply of lottery tickets is a taxable to GST, but lottery department don't need to get itself registered under GST for supply of lottery tickets, and GST payable on lottery are duly being paid by the noticee on behalf of the government of Arunachal Pradesh. Page 104. So, my lord, there is a clear stand of the state of Arunachal Pradesh on our behalf noticee, that means the petitioner is paying the tax. My lord, is the scheme of the act, if it is in the course of interstate trade and commerce, then it has to be paid in the consuming state, and it is a consumption-based tax, my lord. How can my learned friend say we are not depriving anybody? End of the day, my lord, money which goes to the central pool, that is again given to the states. That is the economics, dynamics of the economy, Miller. How can my learned friend raise a grievance that we are not paying anything in Arunachal Pradesh? It's something like a child clamoring for a chocolate.
In this regard, Lordship, therefore, even the state of Arunachal Pradesh, that's respondent number 7, and Union of India respondent number 1. And I'm appearing on behalf of respondent number 2 to 6. So therefore, until unless we file affidavit in opposition, because there subsequent other cases are there, because we need to file affidavit in opposition.
Other cases?
WPC 281, WPC 281, WPC 291, all
These are
2025.
fixed from 28, Miller.
Both.
Yes,
28 of?
this month, next Monday. So my prayer is, my Lord, this should be tagged with that, and Lordship will stay both this registration order and, my Lord, this show cause notice, because no prejudice will be caused to them. Tomorrow, this stay period can be excluded from in counting the period. My Lord, one is 281 of 25, and another
This petition are filed by the same party? or-
same party, my Lord, same petitioner.
Okay.
Page 729 is the order dated 26/25, and page 978 is the order dated 36/25.
978.
Yes, my Lord. And 291 of, sorry, my Lord, 281 या कौन सा? हाँ.
And Lordship, they may be directed to give all the extra copies for.
Yes,
other
yes, we'll give,
respondents.
certainly, certainly.
Yes, because 5 respondents.
Certainly we'll give, my Lord.
For five-
It is our- we are bound to give.
Because we receive only one copy for one
No, no,
respondent.
normally when we move, we give only one copy. Subsequently,
So with due regard to senior.
no, we'll give.
Because they had mentioned particular person, so they might engage other council also, if, right?
So in both the.
Certainly we'll give.
Similar order was passed.
Yes, yes.
Okay.
That was not state lordship,
Yes, yes, state.
not state.
No, state.
291
No,
was
no,
not
all
state
the
lordship.
summons and orders of the trial court were state.
Lordship.
Yes, yes, it is
Yes,
state.
now let me clarify. In WPC 281, that was challenging regarding the criminal complaint before the
Yes.
JMFC.
And what is the ground?
Yeah.
Jurisdiction.
That's fine. That's not regarding the inquiry and investigation.
No. It's
So therefore, we were also praying only that if their representative appear before the investigating officer, then that criminal complaint it's infrastructure.
29.
So therefore, that was state. But subsequently, they challenged the inquiry, this inquiry case, CJC case, in WPC 291. That was not state lordship.
Milord,
There was only direction that no coercive action. So it's
Milord,
here in their
the
petition
lordships
only.
will get the order at page number 729, first order. 729, my lord. And the operative portion is at 731. The first subpara, considering that petitioner's company, although is an authorized distributor of state of Arunachal Pradesh lottery, the selling of lottery is only in the state of Maharashtra and Punjab, with GST registration in the state of Tamil Nadu, and the notices and summons issued by GST authority in the state of Arunachal Pradesh, the complaint being so and so filed by GST authority based on which summons were issued. I am inclined to stay the orders dated 12/6/25 and 16/6/25. These were, my lord, the orders by which the cognizance was taken, and it has been stayed. Why
Lord-
it has been stayed? Because you have got no jurisdiction, you are not the proper official, you cannot initiate.
Lordship, that's regarding
And
criminal
summons.
complaint.
And the second case, my lord, second order is at
978.
978. Yes.
Here, not state lords.
No coercive measure. No, that's it. No, what was the stage? You should not have proceeded, but you have proceeded. We said you should not register. Court said no coercive measure, but you proceeded. You have violated the court's order also. Kindly see, my lord, middle of the night, 987. Huh? 978, my lord.
Yes, 978.
But most important is page 980, my lord. Kindly can see. Considering that the petitioner through the distributor of the state lottery of Arunachal Pradesh, they are selling lottery, state lottery in other states. And this aspect of the matters were taken note of, that we are staying in and paying required taxes. After registration under GST and paid the minimum guarantee so and so, appears to be prima facie not the proper officer. Here also you have issued the registration and the so-called notice as a proper officer. You are not the proper officer according to the Honorable Court, prima facie.
No, we were asked to file affidavit in opposition, Lordship. So therefore, there was no stay in
It is
page
provided
980.
that no coercive action shall be a petitioner and their representative in connection with inquiry. This inquiry has led to the Milord, this show cause notice. Now ultimately it has culminated into that show cause notice.
Lordship, regarding no coercive action, this by Honorable Apex Court in Niharika case.
No, that is a criminal case. That is a different context.
That's why in regarding.
Actually, in terms of this order, you should not have proceeded with. Should have shown due
No.
regards to the authority of the.
Not proceeding in the sense that will be stay. They prayed for stay, but
Here in this case, the challenge is,
Yes, we have challenged this registration order and notice, Milord.
Registration.
Show cause notice. These are the two orders under challenge.
and they can answer there in appellate forum only.
Okay, so what we'll do, we'll take it to the board, the application number 281, 291.
Yes, Milord.
Okay, and similar order will pass.
Till then, Milord, they will not take any action pursuant to the show cause notice, Milord. And registration.
Okay.
And tomorrow is the hearing date, Milord. Tomorrow. In that proceeding.
Okay.
The hearing, they
In
just
the
need
show cause.
to
No, no, no. How can you
answer
proceed?
only, nothing is there.
Hearing date means where?
Yes, before the authority, tomorrow.
I hope
That's
that
why
case.
we, with all urgency, we came and moved this petition.
Lordship, in that case, nothing is there. Just they need to answer some question. That's only whether those document or lottery, total numbers of lottery being sold by
Question
them.
with some information. It's a question of jurisdiction. First of all, whether you are the proper officer, let that be determined by the court. Don't argue like a small boy.
So, this, okay, the date for the.
Tomorrow is the date for our
the
answer.
Next date in the above read petitions.
28,
The
Milord.
next 28,
Next
7.
month. Yes, 28.
Okay. So this will be, this also will be fixed on
Milord,
28.
that I will respectfully pray. And Milord, they will not proceed further pursuant to the show cause registration and show cause notice.
So since you are filing
Affidavit in opposition.
affidavit,
Ah.
Yes.
so you file here also here in this.
Yes.
Yes.
They are in this 2-3 days we'll filing
Okay.
those
The
affidavit in
state,
opposition.
any submission?
Yes.
State,
My lord, since we are selling together, any query for your lordship so that I can answer, my lord.
okay. So similar order and then the date will be fixed on 28.
Yes,
7. Okay, I'll pass order.
And Milord, will not, we should be exempted from appearing tomorrow, Milord.
Lordship,
So,
No, Milord, what?
They are
no,
already- already-
1 second. Milord will kindly appreciate one thing, Milord.
and
We are raising the jurisdictional issue. Tomorrow, Milord, if the jurisdictional issue is decided against us, we will be bound to go back to them. Supposing, Milord, we go and tomorrow the jurisdiction is decided in our favor, then serious prejudice will be caused to us.
in the earlier petition, no coercive action.
No, no,
Yeah.
first read petition stayed.
that was
First
the
read petition,
criminal
the
complaint.
orders by which cognizance was taken was stayed.
Lordship, that's something different case.
Tomorrow is the date of personal hearing. Why should you go and hear before a person when we are already paying the tax, Milord? We can't subject ourselves to an authority who is not the jurisdictional authority in this case.
Be,
Can you see, Milord? Tomorrow is the date of personal hearing. No coercive
If-
action will not do anything in this case,
if
Milord.
they have
If to,
justified
and
reason-
Milord, I have already shown from section 75, if tomorrow we do not succeed, then my lord, this period will be excluded. There will be no prejudice to the department. Well, prima facie, we have paid 48.13 crore. I have shown from this table. And on what basis did 98 crore has been calculated, my lord? And I have shown the conduct of this officer. He has been indicted by 2 different high courts for it. And my lord, the Bombay case is similar like this. Same stand. Bombay case, and Supreme Court upheld the order.
Officers are not doing for their personal interest, Lordship. They are just.
No. Some officers at times work to satisfy their ego. We have seen these officers would have been done their part diligently. This country would have prospered much better. Let us not
Because
say.
everything is recorded through data, and this everything is on this digital portal only. There is nothing like anything has been written down by hand.
No,
It's,
my lord.
everything has been retrieved through data only.
My lord, let the matter be taken up on 28th. Till that, my lord, they will not give effect to these orders. That's all. Thereafter, Lord, let them file their affidavit. Let them show that order whereby this commissioner has been declared as a proper authority. Let them produce the document from the board. Then Lordship will take a call. And my learned friend is referring to Rule 16. Rule 16 also speaks of proper officer. You are not the proper officer.
Lordship, Rule 16 talks about, it's about the investigating officer. If any inquiry is there.
Oh, it is the proper officer who will do the inquiry, not every time.
And for the appraisal of my senior counsel, Section 70, any commissioner,
Mr. K. N. Chaudhary, non-senior counsel, as he said by Mr.
My lord, Abhishek Singh, Nitin Kanwar.
Non-counsel for the petitioners. By filing these petitions, the petitioner challenged the order of grant of temporary registration or
Yes,
so
my lord.
so
Yes.
registration, so registration. Dated 36/2020.
And the draft so cause notice.
And then form of registration. This was by
the respondent number 5.
by the respondent number 5. But against the petitioner future gaming and hotel service private limited by the respondent number 5. And the draft so-called notice under section 74(1) and 74(a) within bracket 1 of the Central Goods and Services Tax 2017.
Respondent number 4, my lord, not
Issued
5.
by the respondent number 4.
Yes, superintendent is the 4.
Mr. Kevin, for the Senior Counsel, some statute. As per the provision of CGST Act, the CGST authority Itanagar has no jurisdiction to initiate this promoter registration is for inquiry.
No, my lord, they have registered us. Therefore, the second stage we will be liable to pay tax, GST.
Okay.
My lord, I may just indicate one thing, my lord. They want to register us under CGST and Arunachal Pradesh GST.
Okay.
We say we are covered by IGST and we are paying IGST. That is the case.
Yeah,
End of the day, rate is same, Milord.
CGST, CGST.
Rate is same.
Hmm.
Rate under the IGST or CGST is same, Milord. It's not that we are not paying. We are paying. Now, if we are to pay again to them, Milord, it will be double taxes. That is against the constitutional mandate.
The credit will go to the municipal.
No jurisdiction to register, that means.
Yes,
No jurisdiction.
precisely.
To register
And to make any inquiry.
and to make any inquiry
And to issue the show cause, draft show cause notice.
against the petitioners. As the petitioner is not selling any lottery in the state of Arunachal Pradesh.
Yes,
Though they are authorized distributor of state lottery.
yes.
Stuff.
State organized lottery, Milord.
No, state organized lottery. Stuff. Lotteries are sold in
State of Punjab and Maharashtra.
Punjab and
And this aspect was taken note of by the earlier two orders, Milord.
yes.
And that proper officer part, prime officer satisfaction is already recorded.
Since
Second
the
order.
lotteries are sold in the state of Maharashtra and Punjab.
Punjab.
Punjab. The petitioner have registered in those states and paying the required tax, and they are not required to register in the state of Arunachal Pradesh. Therefore, registration of the registration
And issuance of show cause notice
and issuance of so-called notice
is without jurisdiction, Milord.
against the petitioner is without jurisdiction.
And to this effect, Milord, the second order, this is a clear finding at page 987.
Issue notice returnable by
28.
28/7/2020 Since Mr. R.S. Navin, respondent number
And for 7 members.
Seven.
okay, Mr. Ipa.
Keep up for respondent number 2, 3, 4, 5, and 6. Lordship, that extra copy.
Of course, by tomorrow you'll get it.
Enter appearance and accepted notice on behalf of the respondent number 1, 2,
2, 3, 4, 5,
okay, 2, 3,
and
4,
6.
5. 1 is for,
I am for respondent number 1, appearing on behalf of DSJM Cut.
okay, okay, Miss
Yes,
appearing on behalf of Mr.
DSJM Cut.
Kato.
DS,
DS.
GI,
Yeah.
Deputy Solicitor
And
General.
Mr. Keeper. Dana Council. For the CGST, entered appearance and accepted notice on behalf of the respondent number 1. So 2 to 4, 2 to, but 6.
6. Lordship. An extra copy.
Mr. R.S. Navin, additional advocate general, Arunachal Pradesh, and C, and Keeper. No formal notice need be served. However, it could be extra copy
By tomorrow evening, Milord. By tomorrow second half will give, because
furnished to
quite bulky.
furnish.
Tomorrow, Milord.
Okay.
During the course of the day.
Lordship, respondent number 2, 3, 4, and 5.
Yes.
That may be clearly
No,
reflected.
we'll give as many copies as these required.
We'll say within 2 days, okay?
Yes.
Okay, within 2 days.
And if Lordship, from page number 1114 to this 1128, some those transactions.
We'll keep,
what are
Milord.
not-
Complete set.
Yes, not visible enough.
Okay, we'll
If
keep,
they-
we'll keep.
that-
Certainly, will.
Considering that the petitioner, though the distributor of the state lottery of Arunachal Pradesh, They are selling the state property in the state of state and the other state and paying the required taxes. After registration under the GST and pay
IGST Act, my lord.
IGST
ठीक है, ठीक है.
and CGST or
IGST.
IGST and pay the minimum and pay the. So you pay the guarantee or guarantee?
Yes,
Guarantee
to the government,
and
yes.
paid guaranteed revenue to the state of Arunachal Pradesh. Okay. And who else? State of Arunachal Pradesh and the
My lord, we are selling in Punjab and Maharashtra, and we are paying under as per section 10(1)(a) of the IGST Act.
okay.
And we have already paid 48.13 crore, my lord, as we have indicated in the chart for the relevant period.
The respondent number 4, who issued the notice and this?
My
Four
lord,
and four and-
show cause is issued by 3
Hmm.
and registration is by 4.
The respondent number 3 and 4 appears to be prima facie, not the proper authority. Comma, it is provided that. And also, the operation of
The show cause notice, my lord.
the so-called
That's the registration and show cause. Show
the
notice,
registration dated 30,
both dated 36.
okay, same day.
The same, that was the last date, midnight.
36, 25, and the so-called under section 71 and 74A, say 74(1) and 74A within bracket 1 of the second CGST 2017. Shall not be
Given effect to.
given effect till the next returnable date.
Developed.
List and
हो गया भाई.
along with the WPC number 281, 2024.
28,
25.
28.
2025, and WPC number 291, 2025, on 28/7/2025.
Developed.
High level, I think.
Yes.
Yes, Your Worship. Your Worship, the present petition is filed for direction to the respondent authority to recall or modify the impugned partial compensation order dated 8/7/2025, issued by the respondent number 1 without the considering of the decree passed on 25th August 2023, Your Lordship. So this is against the principle of settled law and prejudice upon the petitioner, Your Lordship. The impugned order is in page number 25, Your Lordship, of our petition. Last page, Your Lordship. Last page, yes, Your Lordship. May I read, Your Lordship?
Listen,
Yeah,
is
25, Your Lordship, last page, annexure 6.
this is the impugned order.
Yes, sir, this is an impugned order
the second last para, Your Worship. After hearing the matter at length, the payment of compensation against all the properties like house, horticulture items, etc. standing in the proposed strait from Pampam Yorlong to Taking Lingtak should be released without further delay. The payment of land compensation against the strait from Pampam Yorlong to Taking Lingtak is hereby kept at hold till the title of the land is amicably settled at appropriate forum. Your Lordship, this is
You are agreed by which one?
yes, Your Lordship. I'm
Agreed by which one? The last,
Your Lordship.
agreed by which the payment
Yeah, the last one, the last para, Your Lordship, the payment of land compensation
against
against the
strait
stress. Yeah.
from
From Pompom Yorlot to Taking Liktak is hereby kept at hold till the title of the land is amicably settled and appropriate forum. At appropriate forum. Your Lordship, kindly come to the page number 18 of our petition. Sir, Your Lordship, this is not a disputed land. In fact, on 25 of August 2023, Your Lordship, the decree has been passed, Your Lordship. I would like to read the para, Your Lordship, the relevant para. May I, Your Lordship?
Yeah.
As a result, the Kebang Committee Authority have arrived to a final decision of the case on 26th,
You
4th
are
of...
reading which one?
So, Your Lordship,
Okay.
yeah, second page.
Just a minute, just a minute. This is executive order.
Yes, Your Lordship, this is a decree order passed by the...
Just a minute. Okay, then as a result, the
As a result, the Kebang Committee Authority have arrived to a final decision of the case on 26/4/2021, and copy of the final decision has been submitted to the office of the undersigned. In the Kebang decision, it has been declared that so we came to conclusion that this disputed land from Rampampam Yarlo to Bos Sekong belongs to both brothers, that is Hemi Hedu clan community. Further, an application has been submitted by Sri Tabar Hemi, General Secretary, Hemi Land Management and Development Committee, and Sri Gopal Hemi, Vice President, Hemi Land Management and Development Committee, requesting this office for execution and enforcement of the order or decree passed by the village authority as per relevant section of the law, since due to the pendency-like situation of the case, there may be breach of peace which may further affect other development activities and peace and tranquility of the area. Therefore, driving strength from the section 4 clause 1 to clause A, B of the Arunachal Pradesh Civil Code Amendment Act 2022, and also in order to maintain peace under section 145 CRPC, this executive order is hereby issued and enforced as per the decision of the village authority committee dated so and so. The land in dispute from Pampong Yarlo to Bos Sokong shall belong to both brothers, that is Hemi clan and Hedu clan. So, Your Lordship,
you are for?
I am for this Hemi clan, Your Lordship.
And the respondents
Are Hedo clan. But we are challenging the order, the impugn order of the DC, Your Lordship, Deputy Commissioner of COMB.
This was passed by the, in the Annexure 3, Annexure 2, page 18 was passed by Executive Magistrate.
After that, there's no challenge. They did not file any appeal before the authority, appropriate authority, Your Lordship. Suddenly, they have issued now this order, Your Lordship.
So this order was issued or passed on what basis? Based on what?
Your Lordship, actually, since compensation money is there, so before the dispersal of the compensation amount, the acquisition authority, they asked for the joint resolution, Your Lordship, to submit the joint resolution from the Hedu and Hemi clan, Your Lordship. But the Hedu clan refused to do that, Your Lordship. So because of that,
they are asked to submit joint.
Joint resolution, Your Lordship.
So despite of having this order,
Yes, Your Lordship. They were refused to do that. So because of that only, we make a representation to the to the deputy commissioner, to the appropriate forum, Your Lordship, deputy commissioner. And after that, the deputy commissioner issued a notice, Your Lordship. So in the notice, it's in page number 21, Your Lordship.
the deputy commissioner issued this notice based on what?
On after we submitted the letter, Your Lordship, representation to the department,
The representation was written by
written by me, Your Lordship.
Hemi,
Yes, Your Lordship, by Hemi.
saying what?
Saying that the Hedu clan, they are refusing to submit the joint resolution, Your Lordship.
Where is the letter issued by the deputy commissioner asking both the parties to submit joint?
It's in page number 21, Your Lordship. Page number 21, annexure number 5, Your Lordship. It may I read, Your Lordship?
Yes.
Whereas a complaint letter dated 11/6/2025 received from the Vice President Hemi Welfare Society, Hemi Village, so and so, regarding complaint against payment of compensation in respect of land stretched from Pampum Yarlo to taking
That
Lingta.
means thereafter,
Yes, Your
even
Lordship.
after that executive order, complaint was lodged by
But Hemi, Your Lordship, that is us, Your Lordship, that's me. Your Lordship, the order was passed, the decree was passed in 2023. After that, they did not come for the appeal, nothing, Your Lordship. And suddenly, since the compensation amounts is they have received the compensation amount, the department. That's why the department asked the acquisition authority, they asked for the joint resolution to submit, Your Lordship, before disperse the compensation amount. So during that, the Hedo clan, they refused to do that, Your Lordship. So because of that, we have to submit an application before the DC, the Deputy Commissioner, Your Lordship. And in fact, we came to know that on 16/6/2025, even they have submitted the application. After that, this on 30 June 2025, the notice has been issued from the Office of Deputy Commissioner, Your Lordship. So they have fixed the meeting on 8th July 2025
the complaint was submitted by you.
by me, Your Lordship, Hemi Welfare.
11/6.
Yes, sir.
11/6.
11/6, yes, Your Lordship. That is me.
Notice was issued to both Hemi and
Hedo, sir.
Hedo.
Yes, Your Lordship.
Just a minute. Notice for what? Asking them to submit.
Not at submit, not this one, Your Lordship. This is for the hearing, Your Lordship.
Okay, the annexure 4.
Yes, Your Lordship.
Yes,
Annexure
hearing.
4. Yes, for hearing.
Hearing if there is any dispute.
Yes, Your Lordship.
Okay, then thereafter,
Thereafter, they have, yes, Your Lordship. The order has been passed, Your Lordship. On that day only.
okay, hearing was done.
Yes, Your Lordship. Hearing was done.
After hearing,
Yes, after hearing,
the deputy commissioner passed this impugn.
impugn order. Yes, Your Lordship. So, Your Lordship, the decree has been passed in 2023, Your Lordship. And in that decree, it was clearly written the land disputed, the area, the land belongs to both the parties. That is Hemi and Hedu, Your Lordship. So if they have a problem with the decision, they would have challenged before the appropriate court. But they did not do that, Your Lordship.
No, why don't you make an application before the deputy commissioner? Because both are, as per this executive order, both are possessing the said land. Both are owner, isn't it?
Yes, Your Lordship.
Why don't you claim the deputy commissioner to release your part?
That is the reason, Your Lordship, when we come to the deputy commissioner.
Now the deputy commissioner only says that hold.
Yes, Your Lordship.
Till the title.
Yes,
There's
Lordship.
a title.
Yes, Your
Has
Lordship.
anyone filed that suit?
No, sir, no one.
Then what direction you are seeking from this court?
Your Lordship, to rectify, to recall the order, the impugn order, Your Lordship, to direct the deputy commissioner for the rectify or recall this order, Your Lordship. Because this is a partial.
No. So
Yes, Your
see, if both the parties doesn't agree with, then how the deputy commissioner, on what basis he will recall the order?
Your Lordship.
No, because it's you who is decide. Both the party has to come into consensus. And then if you are agreed, you can make application before the deputy commissioner.
We have done it, Your Lordship.
Since
We have already submitted the
referring to the executive order, that both are the owner of the land. So that means each party is
Yes.
owning half of the land, each
Yes.
clan.
Yes, Your Lordship.
Okay, then why don't you make an application before the deputy commissioner?
Your Lordship, we did it, but no reply.
Where is it?
It's in page number 22, Your Lordship.
20
Annexure 5.
22.
22, Your Lordship. Page number 22.
No, this was after passing of the impugn order.
Yes, Your Lordship. After passing the impugn order.
On the same day.
Yes, on the same date, we have submitted this, but we have not received any response from the department. Your Lordship, our ground is
Any order pass into this?
no, Your
Page
Lordship.
7?
No, Your Lordship. We have not received any.
Let him pass order. You make a, why don't you make a reminder to dispose of this?
Yes, sir, but till then, Your Lordship, since the order has been already passed, here in the second line, in the impugn order, Your Lordship, the deputy commissioner stated that after hearing the matter at length, the payment of compensation against all the properties like house, horticulture, item etc. standing in the proposed stretch from Pampum Yarlo to taking Liktak should be released without further delay. So, Your Lordship, it will create a misunderstanding between the clan, Your Lordship. Because of this only, Your Lordship, we are here. Whether it should be stated.
This second last paragraph is with regards to which land?
Sorry, Your Lordship.
This second last, after hearing matter.
It's the same only, Your Lordship. But they are saying that they want to disperse the payment only of those house, horticulture and all, Your Lordship, not for the land. So it will create a huge misunderstanding between the clan brothers, Your Lordship. Whereas it is already, the decree has been already passed in 2023, Your Lordship. That's why we are here, because of this order, Your Lordship. It will create a misunderstanding between the two clans, two brothers, Your Lordship. Not only now, but for the future also, Your Lordship.
Deputy Commissioner has passed this order in what capacity? Whether this was in under any provision?
No, Your Lordship.
No appeal provision?
Yes, Your Lordship.
You are representing Hemi.
Yes, Your Lordship.
Hemi clan, you yourself has prayed for before the Deputy Commissioner for halting of payment of the compensation.
Yes, Your Lordship.
Accordingly, order was done. Why?
Yes, Your Lordship. Yes, Your Lordship.
Why you are challenging? Because it was on your prayer only this order was passed, it appeared.
Yes, Your Lordship. The thing is, Your Lordship, to disperse the compensation money, we have to submit a joint resolution from both the parties. But the Hedu clan, they refuse to do it. And because of that only, the compensation amounts, they are not able to disperse. So that's why we have submitted the application before the deputy commissioner. That,
For
no,
voting.
yes, your lordship, because
Then you see that accordingly the order was passed, then.
but your lordship, this is a partial, your lordship. Because your lordship, if he wants to stay the complete entire compensation, he could have do that instead of partial payment compensation, your lordship. He
So
is
you are agree
depriving.
by which one then? Which part? The one is for payment, one is for hold. You are agree by which one?
Your lordship, we are agree for the both the things, your lordship, because that is the land, that lands belong from to all of us. And some people, some Hemi brothers, they have a house or something, horticulture items there, but some they don't have, your lordship. So if you issue a disperse the compensation only for the householder, a house or horticulture items, then that they are depriving some of the brothers, your lordship, the right to receive the compensation, your lordship, land compensation. So they are depriving it to some of the clans, your lordship.
So you want that entire thing should be hold.
Yes, your lordship, whether it should be hold or whether it should be dispersed, your lordship. But not half-half, because it will create a misunderstanding between all the brothers, your lordship.
What is your prayer? Let us see.
To set aside and quash an alterous modification, cancel the impugned order dated 8/7 issued by the Deputy Commissioner, your lordship, 2025. And may allow that if in near future any correction, your lordship, and to issue a direction to the respondent authority, more particularly, your lordship.
No, to set.
And yes, your lordship.
Your prayer is to set aside.
Yes, your lordship.
So this was on this order
Set
was
at-
passed. This order was passed based on your prayer only.
Yes, your lordship.
So now-
Or your lordship, modification, I have, in my prayer, it clearly is written that modification and alteration also, your lordship. Modification and alteration.
Now, how do we modify?
Your lordship, the honorable court direct the deputy commissioner to settle the matter in his capacity, your lordship. But if he issue if he disperse the payment, then it would be difficult for all the people, your lordship. It will create a misunderstanding between the brothers. That is my concern, your lordship.
No, there should be specific which one you want to stay. Which one grievance against which part of the order? One for granting compensation.
Yes, your lordship.
And the second, the last paragraph is for stay. So to hold.
Your lordship, I give the freedom to the honorable court also. Yeah, in the D also, causes been shown, and after hearing the parties, be pleased to make rule absolute and pass such further order.
Rule to what?
To the order, your lordship, the
Yes,
impugned order.
there is a two part.
Yes, your
Let's say
lordship.
there
Yes,
is
your
two
lordship.
part.
Yes, your lordship.
One is to pay compensation
Yes, your lordship.
against all the properties like houses,
Yes, your lordship.
etc. And one is to
Yes,
pay
your lordship.
compensation to hold.
Yes, your lordship.
Two order.
Yes,
Which
your-
one you want? You are praying for which one?
Your lordship, otherwise it should be released released all, or otherwise not, your lordship. That is my prayer. Since in the order, the deputy commissioner stated that after he wants to disperse some amount of which is related to the property like house and horticulture, or he is saying that the payment of land compensation against the stress from so and so should be kept on hold.
We have not clarified here. And then modification we can't do.
Your lordship, this honorable court can direct the deputy commissioner to holding one hearing, your lordship. Till then, to hold one hearing. Until then, to status quo might be granted, Your Lordship, regarding this order. It will be like difficulty for the brothers, Your Lordship. Between the brothers, there will be fight. It will create the tension between the brothers, Your Lordship.
Yes. So,
My lord, first of all, this writ petition,
ah,
the affected party, the other side has not been made a party.
not my party also.
Yes, my lord.
Okay.
Here it seems there are
Yes,
There
Hedu
is a-
party is to be made party here then.
Hemi and Hedu,
Yes, Your Lordship.
but no one from the
You are- So. Have you understood the prayer?
even me, I have not, on one side, they are claiming that compensation should not be disbursed. On the other side, is
Okay.
they are praying that it should be disbursed.
So what is the main prayer?
My lord, in fact, this writ petition is not maintainable. Why? Because, first of all, necessary party, the
No,
affected,
not implemented.
not impleted.
Now-
Secondly, it seems that
I think you
This
have to
is-
clarify yourself, which prayer.
Yes, Your
Because there is a two part,
Yes, Your Lordship.
whether one granting to pay compensation
Yes, Your Lordship.
and the other is hold,
Hmm.
okay, for land.
Yes, Your
So
Lordship.
you have to clarify which part you want to stay or which part you want to.
Yes, Your Lordship, for that. Your Lordship, as of now, it's very.
And you have not made the Hedu party also as a.
Hedu
They are necessary party.
Yes, Your Lordship, we will.
Any order pass.
Yes, Your
is
Lordship.
going to adversely or affect
Yes, Your Lordship.
the Hemu party.
Yes, Your
Hedu party.
Yes, Your Lordship.
So they need to be made as responding
And-
party.
my lord, it seems that this is for the release of compensation. Release of compensation,
Yes.
land compensation.
Yes.
Land compensation acquisition process is under a certain act. My lord. Whether it is not clear from here, whether it was done under the Adjournment regulation or the right to fair compensation. If it is done in either of the acts, there are provisions. If they are disputing the amount of compensation for the apportionment between the parties, that also it should be under that provisions of those acts. So
Whether-
here simply coming in this form, it will not suffice because this honorable court will not decide the right and title of these brothers.
Yes, yes, that is what I'm saying. Okay, Lana Council.
Yes, Your Lordship.
So it will be better. You make one representation before the deputy commissioner
Yes, Your Lordship.
to modify this order.
Yes.
Review.
Yes.
A review of this order, okay?
Yes, Your
And
Lordship.
better withdraw the writ petition and then after date,
Yes, Your Lordship.
give him some date,
Yes, Your Lordship.
1 week, 2 week, whatever may
Yes,
be,
Your Lordship.
for.
Let her exercise under what provision the land
And the
acquisition was
state
initiated and
Yes,
what are the remedies in that.
Simply the respondent party also,
Yes, Your Lordship.
after completing, exhausting all those.
Yes,
Okay,
Your Lordship.
better withdraw.
Okay, sir. Your Lordship. I would like to.
Miss Jong.
With liberty, Your Lordship.
Yes, Miss Jongloju. Jyoti Jongloju, Lana Council for a petitioner wants to withdraw this with petition with liberty to file a press after making necessary correction. This with petition is disposed. Closed, no?
Dispose on
Disposed of with liberty is. Okay.
Highly obliged, Your Lordship.
My lord, the petitioner before.
Other matter probably we will not be able to today.
Yes.
So one matter may be fixed with the consent of both the parties.
Yes, please.
Whether this item 20 and 21, I have got the consent of Mr. Kara.
Okay,
Which should be
okay,
listed
Mr.
on fourth.
Okay,
That should be
Mr.
listed
T.
on
Tara,
fourth.
Land Council for the
In the main
petitioner.
case, the
with
report was
Land
all-
Council for the respondent. You are for respondent, I think.
She is here.
Your Lordship, I'm on behalf of Mr. Tigar.
Okay, Mr. T. Tara, Land Council for the respondent.
I am for the writ petition.
You are for in the 20 and 21?
Yes, report.
Okay. Then when do you want? When do you want? Okay, formally joint prayer made by both the Land Council for the parties. Let this matter be listed on 4th August. Okay, 4th August.
20 and 21.
Yes, 20 and 21. Okay, and
Your Lordship, and item number 18.
18.
Yes, Lordship.
2021, 4th, 5th to 4th, huh? Okay, item 18. Miss,
B. Mema, on behalf of Mr. Tigaram.
when do you want?
After 2 weeks.
Okay, on the prayer of Miss. On the prayer, Miss.
B. Mema, Your Lordship.
Okay, Land Council for, you are for the petitioner.
Petitioner, Your.
Yes, let this matter be listed after 2 weeks. Okay.
My lord, I'm appearing for the respondent number 3 to 5.
Yeah.
Item number 19. Item number 19.
Item 19.
Yes, respondent numbers 3 to 5.
Who is praying for in item 19?
Yes,
Lordship, he's the respondent.
I'm
I'm a
respondent.
petitioner.
You have no objection?
I'm a petitioner.
Okay.
Maybe I'm filing my Bakalat Nama and I'll file the affidavit.
Mr. Regum,
Record.
okay, R. Navam, Land Council for the petitioner is present. Mr.
R. Milo, Radhe Milo.
Land Council would appear on behalf of the respondent. And praise
3
for
to
some
5.
time-
3
praise for
to
some
private
time-
respondent.
praise for some time, file Wakalat Nama, prayer allowed, list this matter after 2 weeks, 3 weeks. Okay, 3 weeks, okay.
Lordship, intend to continue, intend to continue.
Para, the
I'll-
existing order passed earlier shall continue till the next date of listing. Okay, yes.
So item number 22 and 23, the tag matters.
Okay.
These matters are important matters regarding supply, and we've challenged that order of supply.
Hmm.
And since there is no interim order, we're praying that this matter will be listed on a short date. Can it be on 28?
The difficulty is, Mr. Picha is a standing counsel. Very recently. So.
Picha.
Picha. So therefore, my lord, we are of the considered apprehension that his health condition may not be in that condition to appear before this court for at least for 1 or 2 months.
His
So,
judge is representing.
his judge is representing.
Okay.
Still making a submission that he would able to appear after 2 weeks. But my lord, the predicament that will cause to us would be there is no stay order because there is a this is a matter relating to NIT for supply matters.
Okay.
Now here, firstly, my lord will appreciate that in the district level there was a bid evaluation where we were recommended as L1. But subsequently in the directorate, they have that, again, they have evaluated, then the L3 was given.
Anyway, when do you want? Mr.
We, my lord,
We are praying
make
for a
it
short date.
Short date on 4th, then in the meantime,
I am being informed that I am being directed that he will appear after 2 weeks.
Okay.
Better maybe 6 for disposal.
Well, Lordship, we'll pray for a status quo order then,
my
Lordship.
lord, my lord.
11 of us.
11 August.
11 was too far.
No, my lord, no, my lord, that, I am sure, I also know the situation. So therefore, my lord, nothing will harm everybody. There is a supply matter. If the status quo is not there till then if the supply is done, then matter
Becomes infructuous.
So therefore, my lord, till such time, till 11, kindly consider status quo. Till then.
No, but in absence of.
So far, when the interim part is concerned, that has been considered earlier.
No, it was never considered.
They have said already, it cannot be considered twice, madam. This has been passed subject to outcome of the. commission, madam.
Okay, if that is there, then no order.
Yes, madam.
Will be passed.
No, my lord, then on 4th.
Lordship, the interim was never rejected.
My lord, on 4th.
No, the only consideration was
My lord, can you?
Then on 4th.
11th.
No, my lord, in that case, let us see, let us see, we will convey them. Assurance will not do here. a question of mental health.
Yes.
If
11.
health of a person is not well, assurance will not be suffice. It is the onerous duty of the state response.
No, then in that case, they will engage some other.
No, sir.
On 4th, my lord, on 4th.
On 4th of August, the lordship.
Where
Also, the
otherwise-
department can always make alternate arrangements. We have
This is the
sympathies with
4th.
Mr. Picha, but the department can always make alternate arrangements.
And
Let us
Mr.
give one chance,
Contempt-
let us give one chance, 11, okay.
On 4th of August.
Madam, till then-
Mr. Land
Well,
Council,
madam, till then-
Land Council, the respondent, number,
Well,
submits
madam,
that.
madam, may I just make a request before I
yes.
pass the order?
Hmm.
There is an urgency in this matter.
Hmm.
If till such time, if the supply is done, the purpose of filing of my writ petition would become.
Both the writ petitions are the
Both the
similar
writ
issues.
Therefore, my lord, let kindly list on 4th. Mr. Tagum has already consented me for 4th.
No, no,
As far as-
that is different.
No, no.
We have to,
No, no.
discuss, we have
No,
to,
no, no.
nothing's going to rescind your, stop, madam. He's requesting the him to appear.
Let us give him one chance,
11
if
August,
he himself
Why
has
should he
stated that
appear?
only after 2 weeks, if he can.
No, no.
Actually, he will appear.
Till then, my lord, till then, this is status quo.
So the department can always
Otherwise,
make
let me-
alternate arrangements.
Make the argument. Department has already filed the affidavit. Department has already filed the affidavit. Mr. Tagum's client is a beneficiary of all illegalities.
Madam,
So he cannot blow north, south and east.
So the L1 bidders have been turned around, have been rejected by a authority who doesn't even have the power to evaluate.
Madam, kindly fix it on 5th, my lord. Kindly fix it on 5th.
Mr. Land Council for the.
Fourth.
Land Council
On
appearing
4th of
on
August,
behalf of
Lordship.
Mr. B. Picha, Land Council for the respondent number.
State respondent.
Oh, it said respondent.
Standing council,
We waited since morning, my lord, to argue this matter.
That his senior is not here, therefore pray for adjournment of the matter. The Land Council for the petitioner has shown some urgency. In view of the above, let the matter be fixed on 4th.
4th of August, Lordship.
4th of August. Great.
Okay, let us see, on 4th.
Yes.
There is-
If he
difficulty,
cannot turn up,
you make a
then we-
prayer, okay?
Department can be alternate.
Okay.
Fine. Affidavit has already been made. Grateful, madam.
Lordship, this item number 17 maybe leaves it after 2 weeks. Item number 17.
Okay, 17, okay,
Your Lordship, interim may be continued.
okay. So, you are for,
This petitioner, on
You are
behalf
for the
of this
petitioner?
conducting council 8 attack.
okay, Mr.
GT Raju.
Land Council for the petitioner, please. On the prayer of Mr. So-and-so, Land Council for the petitioner, this is matter after 3 weeks. Okay, stop. The prayer is allowed, this is after 3 weeks. The interim order pass item shall continue till the next date of listing, okay.
Lordship, I beg.
Second. Lord, item number, that motion matter, my lord, 27.
Yeah.
Lord, what I'm praying for, Lordship will today
Issue notice,
issue notice and keep it on 28th for interim order. It's a suspension matter.
okay.
And my lord, my learned friend Ratan will produce the
Okay.
records.
Okay, hard, Mr.
And interim will be considered on 28th.
Okay, the Chaudhary, Land Assembly Council, assisted by. Okay, Land Council for the petitioner. We'll say issue notice.
Yes.
Issue notice, returnable by state. Okay. Okay.
My lord,
Returnable by which date, when,
28th.
28, okay,
It will come up in admission column.
okay.
Or it can come in motion column, my lord. Lords, it can come in motion column, let them have the instruction and interim orders will be considered. It can be done.
Let me produce the record.
Yes. Let it come in the motion column, my lord.
Okay, then on the prayer of Mr. So-and-so, Senior Counsel, assisted by so-and-so, let this matter be listed again on
28/7.
28, Mino, and Mrata, then additional AG who appear on behalf of the state respondent, shall obtain necessary instruction. And produce
Produce the record.
Same.
And interim order will be considered on that date, my lord.
Let the matter be fixed on 28, on which date the interim prayer shall be considered.
And
Lordship, I beg to mention item number 13, Lordship.
13.
13, Lordship. This matter is, Lordship, today, the two entry, they have filed their affidavit in opposition, Lordship. There is a urgency in this matter, Lordship. This matter maybe, can it be posted again on 30 of this month, Lordship?
Who is for the respondent?
Respondent, Lordship, he's representing NIT, Lordship.
Okay. Okay, Mr. J. Jini, land counsel for the petitioner. What do you want to file, you said?
Lordship, can this matter be posted again on the
Okay.
30 of this month in the admission clause?
On the joint prayer made by both the land counsel for the petitioner, Mr. Jungam Jini and Mr.
As to the.
S
To the for reference number 2 and 3.
for respondent number 2 and 3, let this matter be listed on
30 of this month.
37. Okay.
Lordship, I would like to mention item number 14, Your Lordship.
Item 14.
Yes, Lordship. I am
Okay.
appearing on behalf of Mr. Ayamete.
Wait
Your Lordship, 4 weeks time I will granted to file counter affidavit, Your Lordship.
You are for the respondent.
Yes, Your Lordship.
Okay. Okay. On the prayer of Mr.
K. Terry, Your Lordship.
Land counsel for the respondent number.
Your Lordship, I didn't.
Okay,
I don't-
respondent, huh?
Yes, Your
Then
Lordship.
you would need to mention respondent number. How many respondents are there? Item 14.
Most probably, Your Lordship, it's DC.
Or at least you should know whom you are representing.
Much apologies.
Hmm. You are representing
DC Anjan. DC, Your Lordship.
DC.
Yes, yes.
Only DC.
Yes, Your Lordship.
Okay, so that department. DC is not a party. Okay, Deputy Commissioner Pagli. Okay. For a respondent number praised for and is granted. Huh?
4 weeks, Your Lordship.
For 4 weeks time to file affidavit of opposition. List this matter after 4 weeks. Okay.
Much obliged.
15. Done. And for a pass. Okay. Wherein two Saikia was also present. Okay. None appears on behalf of the parties. List this matter after 2 weeks.
Yeah, Your Lordship, I'm appearing for item number 15 behalf of Mr. M. Kato, DSGI, Your Lordship.
Okay. You are for respondent?
Yes, Your Lordship.
No one appears on behalf of the petitioner on call. Mr.
K. Terry, Your Lordship, on behalf of
Appearing
DSGI.
behalf of Mr. Kato is DSGI. Land counsel for the respondent is present. In absence of the counsel for the petitioner, the matter stand adjourned. List this matter after 3 weeks.
Yes, Lordship.
Okay. Okay. No.